that this is the reason why you have not preferred an appeal.
It can be done. My difficulty is that, my lords.
Also kindly implead the state of Karnataka.
It is submitted that though there is a statutory appeal available to the petitioner,
Please.
petitioner could not avail the same. And certain reasons are stated by the, submitted with the senior counsel for the petitioner. And Leonard AG has taken an objection that the complainant is not made a party to this writ petition. And the state is also not a party. Why the remedy available to the petitioner is not exhausted. Whatever the reasons that are stated before this court, an affidavit in that regard be filed, then this court will consider the same.
Tomorrow, my lords, may I?
Tomorrow?
Yes, because the.
Tomorrow I'll take it up.
I will
Yes.
take, my lords, only my lords, I may be permitted to spend 2 minutes of the honorable court's time.
No, tomorrow I'll hear this.
Yes.
Tomorrow.
Tribunal, my lords, it was argued before the learned tribunal, the learned chairman even will not allow, he only argues.
That's what we'll hear.
Appellate remedy, we are,
We'll
the
look at the
learned.
affidavit and understand it and pass orders.
Yes, yes,
tomorrow.
I will put on taking tomorrow,
Tomorrow.
one more case is also listed.
Yes.
In that also I'll file the affidavit. My lord, let there be an inquiry.
Yes.
How, in Karnataka, if an independent inquiry is ordered to verify all the liquor shops, 75 shops will go. I can take the learned state advocate. Next to my office, one shop has come. Board is grape juice shop. It is so much decorated, much more than any best
Lords,
sari
all
shop
this
in the
is
country.
irrelevant now.
Irrelevant.
Necessary agreements.
So your submission was also not relevant.
Yes, tomorrow.
Please.
Yes.
Please.
Yesterday's matter.
Yes, my lords.
Yes.
May I submit, my lords? On instructions, I submit that, my lords, we'll release the 246 liters of IMFL, my lords.
246 liters of?
One second.
IMF.
Prayer, my lords, 246 liters of IML.
Liquor.
Beer, it is not possible, my lords, because it's being expired. The duration of the expiry is over. So,
What will you do?
That is their mistake, Melo, that no power to. Now, Melo, let them release this.
That is the next question.
Next, that
What
we
will
will.
you do and what is
They have to
like how
compensate,
they're
that they will have to
accountable for
compensate.
that and what is that you are entitled?
As of
to?
now, Melo, I am happy, Melo, let them release this 285 liters,
246.
246 liters.
Hmm.
Then, Melo,
I'll record a statement that the 246 liters IML is, it's an expired.
No, my lords, 246 is not expired.
78.87, the English translated annexure A, Melo.
Page number, it is there here in this.
No, Melo, that's Kannada, the English translated, I'm just. Annexure A, that is.
Mm.
So what he sees was 78.87 liters of beer and 246.
Where do you get that?
My lord, in the type, in the copy which I gave,
246.84 liters of liquor and 78.87 liters of beer.
Now what they're saying is 78.87 liters of beer as time has expired. That is that
So
state.
now they will, as far as 246.84 is concerned,
That will release.
you will release. So shall we dispose of the petition?
Please, please.
Yeah, no, beer and whatever.
And one more submission, my lords. Let this not be a precedent that may be recorded,
Yes.
please.
Lord, let them verify whether it is expired. We are not aware because when it was.
No, it is expired,
Substitute
sir.
is submitted. That I'll
Have to-
record.
They have to, my lord, compensate for that. They had no authority.
Compensation is not possible.
That is whatever you want to do, that is for you to, yes,
Yes.
the present petition is filed, seeking the following prayer.
Between the
The
Mafia
petition is agreed with the order dated. Dated. No, what is this order? Confiscating. No, it is, how can we dispose of the petition? Now we have to decide about this confiscation order, whether it is right or wrong. Isn't it?
Please, my lord.
Then how can it be disposed of? Interim order?
It may be partly allowed, at least.
No. We have to, the Learned Counsel for the petitioner submitted, when the matter came up yesterday, Learned Counsel for the petitioner submitted that the order of seizing the stock is bad. And they have seized 246.84 liters of liquor and 78.87 liters of beer. And if there is no, if the said if that is not, that the said stock is not released, it will expire and will be of no use to the petitioner. pending disposal of this court has directed the learned AGA to get instructions in this regard. On instructions, it is submitted that already in respect of 78.87 liters of beer, it is expired. Considering the fact that pending consideration of this writ petition,
Infectious or
considering the nature of the stock, this court deems it appropriate to direct the respondents. I'll pass it as a code out of the court.
Please.
I'll direct the respondent, this court is directing the respondents to release the 246.84 liters of liquor immediately. The next para, the the objection shall be filed by the respondents. This matter on 4th of August. Yes, next.
List number 2 for orders hearing on A. List number 1 Superintendent K.
Lord, just brief facts,
For vacating stay.
Yes.
brief facts can be disposed of. Brief facts. I am the plaintiff in the commercial court. The defendant number 1 owes me, 1 to 3, they owe me about 3.6 crores. Number, defendant number 4 is the person who has a first line of the property. He had mortgaged the same property first before me, before I could get the mortgage. And he had a loan of about 1 crore odd, 1 crore 40. He was the creditor to D1 to D3. Now, property was put for execution sale. It was put for this security interest sale. 7 crore 7 lakh was recovered. That was on 26/3/25. Now, Lord, they appropriated 1 crore 40 for D4's loan. D4 then filed an application before the commercial court saying that what should I do with the balance? Court can direct whether I have to give it to the debtor or whether I have to hold it for the second loan. There is a condition in the loan agreement between us, between plaintiff and D1 to 3, that this property will continue as a charge of mortgage after the discharging of the loan with D4. There is an agreement. So this agreement binds us. What the commercial court incidentally did was, it said, no, you give an indemnity guarantee, this amount can be released. Now, 3 crore 60 lakhs is my due as per my prayer. One of the prayers in the arbitration case is, after selling the property, whatever is the balance surplus, to the extent that it serves this loan, that must be deposited in the court as a final relief. When this was done by the trial court, we moved this honorable court. This honorable court granted stay and said till disposal, the money shall be kept as it is. It shall not be dispersed. Now, in the meanwhile, though we had a final relief saying that the sale amount should be attached to this suit, we had not filed an application seeking attachment. So we filed the application very next day after the court disposed of and asked the court to recall this money. To show that this person is a continuous defaulter, there is a check bounce case also that is lodged against him, and he has not repaid the money despite the check bounce. Now the due is, so the surplus is about 5 crores.
Where is the order of the court?
Order of the court is. Annexure A, page 20. IA1 filed by the defendant number 4 under section 151 CPC is hereby allowed. Defendant number 4 is hereby permitted to hand over the DD bearing so and so dated 31/7/25 for 5 crore 68 lakh 45 drawn in the name of defendant number 1 to the defendant number 2 and 3. The defendant number 1 to 3 are hereby directed to execute indemnity bond by undertaking the deposit to deposit the said amount before this court if a direction is issued to them in the future. Plaintiff absent, defendant number 2 and 3 are present, defendant number 4 absent, no representation. Counsel appearing for the plaintiff, defendant number 2 3 are present. And that day I was also absent. It records that plaintiff is absent. Very next day I filed an application asking to keep this amount in deposit before this court. Now, Lord, there is an agreement between us, binding agreement, Kindly see the very next page 25. Page 25. Because this loan was taken as a second loan over that mortgage property.
Where is that application of yours
Our application, yes. There is
after this order?
after this order, application. Page 62.
Page 60?
62.
62, my lords, was an application filed along with the plaint.
For the reasons stated in the accompanying affidavit, plaintiff prays this honorable court be pleased to
So
pass an order
seek
attachment.
Judgment,
Yes.
68, my lords.
some other order.
Lords, the application filed is at page 68.
68. No, that is to suspend the order date
Yeah.
1010.
The
Both of them are
application at
filed
page
70.
62, my lords, was filed along with the plaint.
No, I am asking about that. Which is the application filed after this order is passed?
No, that is 62.
Page 68.
Two IAs. Two IAs were filed. One to attach, another to suspend the 1010 order. Where the court had said,
That's when
you
application was
can,
filed
you
along
can
with the
release.
plaint. That's,
Both together.
the plaint ಜೊತೆ ಹಾಕಿತ್ತು 38 rule 5. Some,
No, it is there, it is 66 al reference there, 1010 order. Plaintiff submits that the fourth defendant hand over the demand draft as per the order of this court at 10:10:25. Plaintiff will not be able to recover its dues. Both these applications were filed.
The 62 application is what? Page 62.
62 is attachment before judgment. 68 is to keep that order in suspension, 1010, which said release the amount.
Please come to the plaint once. Where is the plaint?
Prayer, what? Prayer of
Plaint,
which?
plaint.
Please, no? Suit claim,
Where is that?
I'll just, it has all these prayers. Page 39,
Not about the prayers.
Ah.
So come to this array of parties.
yes. In the
You
suit,
said you have given the loan to the first defendant.
yes.
1, 2, 3.
1, 2, 3, Lord. 1,
Yeah,
2,
the-
3.
Given loan to
Yeah,
one,
represent-
two.
1, 2, 3.
And four?
4 is the first creditor over this property. He had the first mortgage line.
Hmm.
His amount was minor, not about 1.10 crore.
Hmm.
So he recovered it, he sold it for 770. So he recovered his portion, he wanted to deposit
Yes.
the balance.
What do you say? Listen.
lords, the suit was filed and a relief was sought for us against the fourth defendant. They did not make any interlocutory applications seeking protection. By the time they had filed the suit, there is a mentioning in the suit itself that the property was already sold and they were holding the money. Though there was no order against the fourth defendant restraining them from releasing the money, because under the scheme of the SURFACE Act, the moment they sell the property, anything in excess will have to be released in my favor. In the absence of any restraint order by the court, straight away it should have been released. Fourth defendant creates this mischief, otherwise they would not have been before the court. Fourth defendant, instead of releasing the order in the absence of any restraint order, he makes an application saying that permit me to hand over the check, which the court says that you hand over the check. That is all what has happened. But they never made an application earlier to that saying that no, there should be an order of attachment before judgment, or that the money should not be released, so on and so forth.
Now the money is there, is available after selling the property, whatever is the remaining money.
Yes.
So why can't?
Lords, under the SURFACE Act, my lords, because this is a sale under the SURFACE Act.
Is with you?
No, the money is not with me as of now, because your lordships have stayed the order until and unless the money comes to me. Because once the process has commenced under the SURFACE Act, it has to completely complete. It has to go to a logical end. Question of directing that he should not hand over the check does not arise. Then the next question is this, my lords. Whether he is entitled to an attachment before judgment is a matter which is to be considered by the trial court, because he has never argued on that. Because to convert an unsecured loan into a secured loan, my lords, is not something which is openly welcome. That he has to make out a case. We have a valid defense. There is no way that he is going to get an order of attachment before judgment, because whatever loan he says is rendered is actually for the financing for the vehicles. They have already paid the money. This is essentially what has happened. But that's on the defense of the matter. But on the facts now, there is no restraint order. Sale effect under the SURFACE Act, which they have admitted, sale has completed. So whatever is the balance money has to be credited into my account. Fourth defendant created this mischief saying that no, I want to take the permission of the court and hand over the demand draft, which the court says you hand it over. Anything else, they will have to pursue before the trial court. They can't come before this honorable court.
Court also has said that you have to execute an indemnity.
Friends, I'll execute an indemnity bond because that's a part of the order which I have not challenged. So I'll go by that order. But to say that, no, it should not be released is not open to them because that was never a relief which they sought for before the trial court.
It was sought.
No, the order, what is said is that DD is not handed over to you.
Yes.
Yes.
Because that's a relief which, no, they never sought for this relief before the trial court.
Under the surface proceedings, once a property is sold.
Yes.
And
But what happens is.
whatever is the remaining amount, he is entitled.
Yes.
And the bank need not ask the permission of the court because that is the independent proceedings under the Surface
Yes.
Act.
Lord, what?
Now, once a property, the money is with him, next question comes the question of your attachment before judgment.
But the position would be this, Lord. It is not where courts have overarching powers beyond the DRT and securitization. Because courts sit as bodies which render justice in such circumstances. The court's power is overarching, much beyond the securitization act. Assuming the money was anywhere, whether with the recovery officer or in between the auction or after auction, it was yet to be handed over or handed over, court has still the power to hold those money and bring it to the court's jurisdiction.
For an attachment before judgment is the question.
Yes.
That has to be decided.
Let
by
the court decide that, my lord,
Let that be decided.
and the status quo be there with respect to the release of money.
As far as the indemnity bond, the court is asking,
Yes.
that itself is a security.
But
for
what
you.
would happen is, the attachment before judgment is usually based on whether this person is a recurrent defaulter. If court finds he is a recurrent defaulter, then the court holds this money. The issue is as to whether he is liable to default in future or he will go away without paying. So now let the discretion be exercised by the court in the IS that are filed and let the money be kept pending till the decision is taken.
So we'll ask the court to decide both the applications, decide this
Yes.
application.
Yes, because
Yeah, Counsel.
that is issue as to whether he pays or not will be.
Say this, my lords. Now, in the usual course, the money should have been straight away been
Come to
deposited.
you.
Now, they never made this request before the passing of this order, saying that no, there should be a restraint order, or that they should be restrained from holding it back, or they never objected. But the whole issue is this. Now they are asking for something in respect of those applications which is yet to be considered by the court. Now, as on the date when the application was up for consideration before the court, that's not the relief which they sought
Will
for
take
before the
another
court.
1 week to
That-
consider.
Lords,
It
they
will not materially
can't
harm
do
anybody.
this. Lords, there is something called as propriety, with which they will have to conduct themselves. If they are not diligent and they did not take steps, even under the scheme of the act, they have themselves referred. Defendant number 4 in the written statement has taken the stand that since this is a sale under the surface proceedings, whatever we do will be strictly in accordance with the Surface Act. Therefore, the question of giving any directions against us does not arise. We are bound under the provisions of the Surface Act and therefore the suit is not maintainable. This is the defense taken by them. But since they mischievously filed that application and an order is passed, we are before the
But
court.
they have admitted,
And the interim order is passed in this case.
this interim order is on 10/10/25,
No,
11/10/25. And not they admit that they are a defaulter by saying that the check is bounced.
No, from October.
that's for the
no, no,
defense.
From October, there is a stay.
Yes, let the trial court
If your
dispose it
lordships
off.
were
my
to
lord.
see, my lords, we filed an application for vacating stay. Matter came up on a dozen number of occasions. We have argued this matter before the coordinate bench on 4 or 5 occasions. Then the matter got spilled over. So ultimately a decision was not taken. Fact remains that we had filed an application seeking vacating stay. But now the question is this, because if your lordships were to give this direction, then the overarching powers, what he says should be found. That is something which is, if your lordships were to see the written statement filed, it is the specific defense raised by the defendant number 4 in the suit that this is a sale under the Surface Act. Whatever is remaining, we are going to give. You cannot give any directions against us. Now that's an issue which they should have opposed before the trial court when this application was
He
filed.
has,
Lords, kindly have a look at that application, my lords, because they had to file their objections.
I will not find fault with the order that is passed by the court. But any of their application under.
But that's
attachment
subsequent.
before- attachment before
I
judgment.
only direct the court to consider it.
Lords,
Yes,
let that be
Lord, please.
considered, my lords. If your lordships
Please.
is not interfering with the
Within,
order
my lord,
issued, my lords,
within a
then-
period of 1 week, it would be
Within a period of
considered.
1 week,
Till then, status quo.
till such time, let it be.
Yes, my lord.
That's the reason why I said, my lords,
My
in
learned
order
friend
to
wants
give
to
them
avoid
the
that position.
protection, lords, in order to give them the protection, I can understand if there was some interim protection given by the court at an earlier instance, which is now
these are
vacated, which your
technicalities,
lordship is
Lord.
extending, certainly, my lords. They never had the protection till date. Till such time, the fourth defendant created this mischief, we were not before the court and they never made such request.
Lord,
Now merely because the fourth defendant does this mischief, they cannot get a special right than what they had earlier.
he has taken away 4 crores of my money. He does not want to repay it.
They have
Yeah,
taken
that
the
money is
every
lying
single
there.
rupee. This is essentially where
Short,
it lies.
short issue is he can say that I will
No.
repay your money.
Lords, it is very simple, my lord. The short issue.
Kindly see the unjust
They should
position he,
concede, they should
he
concede
stands
to the
at.
fact that the entire
4
money they
crores,
have
he
recovered.
treats it as a
That's
hardly
what
about a lakh
happens.
of
This
rupees.
was purely for the purposes of financing of the vehicles which were borrowed through the borrowers. So those vehicle owners, my lords, had to pay the EMIs.
They have paid him, he has not paid.
They have taken the EMIs, full loan accounts are closed, they have closed their loan accounts. But what they are showing is that whatever loans which has been advanced to them is the loan which is due from me is what they are claiming.
No, that
The
is on
first
merit.
charge which they are holding is as against those vehicles for which they have got the documents.
Lord,
They
vehicles-
never make them as parties in the
Yes,
suit.
right.
The reason why I am telling it, they should be made as parties.
The indemnity bond is executed by you.
Lord, because your lordship's order is stayed, my lord, the order had been stayed. I'll execute it tomorrow itself. Lords, they cannot have a larger relief than what was before the trial court as of the date when the order was
No,
passed.
Before the
It
trial
goes
court,
into the property with which they are now
Lord,
coming
before
before
the trial
my lords.
court,
No,
we
that
had,
application is not considered so far.
No, it is not considered so far.
And
Their
even the
application-
pre-call application, what has happened?
that is also pending.
No, that
That was-
application,
Yes.
that application, my lords, filed there.
It's
They
pending.
did not wait for the adjudication of that application and they moved this honorable court on the next day itself.
Because my learned friend would have taken away the money next day. We
they
had
could
made
not have, so
preparations
they-
to get the direction
if-
from the court.
Now they cannot travel in two boats.
No, bro, repay the money.
If he has already made the application
You have
seeking
taken the
recalling, he has
money.
to pursue that
Lord,
application.
after
there.
giving 4 crores, after undertaking that this will be a second charge on the property, he has to pay it.
Everything is
Kindly
after the
see,
order is
Lord,
passed.
kindly
When
see,
is this order, IA is filed, seeking the.
13,
attachment before
3 days
judgment,
later.
62,
13/10, 3 days later,
13/10.
13/10,
When was the order passed?
10/10,
10/10.
10/10.
10/10.
Yes.
And when was the sale?
Sale was on
Lords, that
26/3.
page number 54 is the application of the
26,
fourth
325.
defendant. Lords, is my kindly
Kindly see,
No, no. This
just a
is
moment,
on,
Lord, just a moment.
this is filed on 29th of August 2025. The IA filed.
Kindly see page 25. 25 for a moment.
Lords, can I just pursue your lords? May I kindly see
20,
page 54, my
no, no.
lords? That's the application. Application is filed on 29th of August 2025.
54.
Order is passed on 10th of October
54.
54. That's the application on which the order is passed and which is impugned before the
What is the
lordships.
application?
They never filed their objections up to 10/10.
Please permit the fourth respondent to hand over the demand.
Yes,
Where's the application?
This is filed by the fourth respondent.
by the fourth defendant on 25th of August,
12, 9 or 8 it is.
29th
Well,
August 2025.
54.
That is D4's application.
Yes,
This application I'm saying. It's on 12/9 I suppose.
12.
I think 12/9/25 is the application is. Bottom of the page, the date is there. So 12/9/25 they filed this application.
Yes.
Order is passed on
10/10/20.
Till such time you have not filed any objections.
objections.
We had not filed the objections. We had not filed the objection.
Have we?
But as soon as when this order was passed,
But
immediately 3 days
That's
later we
That's the
filed.
phase where you have to file this
Yes,
application
but
for
will not,
attachment
don't
before
delete.
judgment.
kindly see page 25. Pari passu arrangements made in banks, where, page 25. The parties make these pari passu arrangements, my lord, so that they can take a second loan, third loan, and those second and third loans are also protected by agreements. Kindly see that pari passu arrangement, 25. What he undertakes in that pari passu.
Yes.
25, kindly see, Lord, two paras from the bottom. Do I have your lordship? Whereas first party has requested second party. Lord, this is even before I could give him the loan. On 1/1/24, January 24. First party has requested second party, I am the second party, to take over the existing loan with HDP Financial Services and shall continue to mortgage said property to second property after the discharge of the said loan with the HDP Financial Services.
Which he never did.
Which one second. Kindly see the top plot, first para. Whereas the first party owns a property bearing 16/4, survey number 16, situated Bahubali Nagar, MES Road, Jalandhar. Now this property, if it is sold in discharge of that first loan, then automatically the second discharge operates.
My lords, he had the
Automatic.
option.
Therefore, that is why I'm
This
saying.
this is
that I
essentially
may
where
be a
we'll have to
little late.
demonstrate.
I may
He
be a
had an
little late in
option
filing the application.
that
This
in the
is his-
event
let
he
me-
wanted the,
Let me complete. This is his undertaking. His
No, that's-
undertaking,
no,
he
no, it
can't go
is-
against it today after
Lords, it
taking
is,
the law.
I just wanted to say this.
Lord,
If
it
they
is very
wanted
easy to take
exercise-
4 crores and then say, I will not abide by this
They have
agreement.
already taken the entire money. This is the, Lords, can I just pursue it to
Can
say
he
this?
go
my lord?
against his undertaking?
No, this was an agreement which was executed to facilitate the closure of the loan account. Now, he did not act upon this document. He never closed the loan account. He did not facilitate the creation of a subsequent mortgage in the event this was required. He, on the other hand, committed a default in terms of this agreement, which he now reads, permitted the property to be sold and then came to the court and
I
saying
filed
that,
the-
no, you will have to give me the
But
money.
I filed the
It's
objections
essentially, my
also.
lords, what happened?
Where is the order page number?
Lords,
Lord,
order
58,
is,
I filed the objections also, Lord, to the defendant force application
Page
on
number?
23/9,
No, where is this? Order?
Order is at page 14,
14.
page 20.
Page 20. Lord, in this order, the court
Page
has,
number? Where is the?
page 20. My objections, Lord, I initially said I had not filed objections. I had filed objections to the 39 application. Those objections are not considered.
Please come.
Yes.
Agreed with the orders passed in
Uh,
I number 5.
What is it? Page 20.
Defendant number 4, under section 151 CPC, dated 10/10/2025. The plaintiff is before this court. The petitioner plaintiff had filed a suit for seeking recovery of an amount of rupees 3 crore 60 lakhs. And also directing the fourth defendant not to create a lien on the scheduled property belonging to the first defendant in respect of the claim of the plaintiff. And directing a fourth defendant to pay the outstanding amount of the defendant's herein to the plaintiff out of the sale consideration received on sale of the scheduled property by it in an auction after adjudicating the liability of the fourth defendant. That is the main prayer itself in the suit.
please, that's the main prayer.
Lord, the objections, when the bank filed, D4 filed the application to keep it in the court, I filed my objections, my lord.
Main
That is at
prayer.
page 59,
Page 50.
59, 58. Plaintiff's objections. The statement of objections are to IA dated so and so by fourth defendant. That's my objection.
This is my objection. This is fourth defendant's application.
To the fourth defendant, kindly see para 9, my lord. By page 60, para 9. Plaintiff's objections. Plaintiff submits, yeah.
The fourth defendant has initiated the proceedings under the Surface Act and put the property to auction and sold the property and the loan of the amount due to the fourth defendant is an amount of rupees 1 crore,
10 lakhs,
1
40
crore.
lakhs, 1 crore 40 lakhs.
1 crore 40 lakhs. And the remaining 3 crores 63 lakhs. With regard to the remaining 3 crores 63 lakhs, the present application is filed by the defendant number 4, permitting to hand over the DD. That is 5 crore 68 lakhs.
Yes.
5 crore 68
60,
lakhs
yes.
45,000
Yes.
134. In that, the court has passed an order stating that the defendant number 1 to 3 are directed to execute the indemnity bond. The DD may be handed over to defendant number 2 to 3, 1 to 3, and they are directed to execute the indemnity bond by undertaking to deposit the amount before the court. If a direction is given to them in future, court observes that the plaintiff is absent, defendant number 2 and 3 are present, defendant number 4 absent, no representation. Counsel appearing for plaintiff and defendant number 1, 2 are present. Call for the complaints of the order on 10/10/2025. and also for filing statement of admissions and denial of documents by 18/10/2025. This order was passed on 10/10/2025. On 13/10/2025, the petitioner plaintiff had filed two IAs. One is to recall the order dated 10/10/2025, and also second IA is filed under order 38/5 for an order of attachment before judgment for the amount of rupees 5 crore 68 lakhs 45,134. Even before the said applications are heard by the court, the petitioner plaintiff has come before this court by filing the instant writ petition. This matter came up before. When was the stay granted initially?
1310.
1310.
On 13/10/2025, a coordinate bench of this court has granted stay of operation of the order dated 10/10/2025, and the respondent defendants 1 to 3 have filed the vacate petition. Next part. Learned senior counsel appearing for the petitioner submits that the main prayer that is sought in the suit itself is that once the property is sold,
Yes.
whatever is the remaining amount that is realized from the proceedings by the fourth respondent shall be given to the plaintiff. It is submitted that when IA number 4 is filed by IA number, what is that? 4, defendant 4's IA?
IA, defendant force IA,
IA number 1 filed by defendant number 4.
yes,
To that, they have filed their detailed objections. At page number?
page number 62. Sorry, at page 58. 58.
They filed the detailed objections to the same on 23/9/2025, wherein they have sought for a relief that the application filed by the defendant may be dismissed. If the said application is allowed, the plaintiff will suffer irreparable loss and injury and will be put to severe hardship. If the surplus amounts realized with the auction sale of the scheduled property is permitted to be paid to defendant number 2 and 3. It is also stated that the four defendants in an unreasonable hurry and is unduly interested in making payment or the surplus sale proceeds to defendant 1 to 3 rather than aiding in rendering justice to the plaintiff and the recovery of the amount justly due to it. It is also further stated that the fourth defendant is legally and morally wrong in requesting an order from the court permitting him to hand over the demand draft for an amount of 5 crore 68 lakhs 41,134. It is a grievance of the plaintiff that the court has not considered the said objections and passed an order directing the DD to be handed over to defendant number 1 to 3. It is further submitted by the senior counsel that the application under order 38/5 is pending consultation, and in the meantime, if this amount is handed over to the defendant, considering the fact that there is a history of the check bonds cases against the defendants 1 to 3, it would be difficult for the plaintiff to recover the amount, and hence there may be a direction to the trial court to dispose of the IA that's filed under order 38/5 until such time this order dated 10/10/2025 will be kept in abeyance. Next part. Senior counsel appearing on behalf of defendants 1 to 3 submits that the property was sold in auction proceedings under the Surface Act and the auction proceedings, and that under the act, once the amount that is due to the bank is stated, the remaining amount has to be the borrower is entitled for the remaining amount. There is no question of placing the same before the court. We submitted that the court has rightly passed an order directing passed an order to to hand over the check to defendant number 1 to 3. It is submitted that the plaintiff application under order 3825 is still is pending consideration.
Is after the
And
filing of the, is after the orders dated 10/10.
after the order is passed on 10/10/2025, these two applications are filed on 13/10/2025. And the one is.
There
to
was no
recall
restraint
and
order as on the date when the bank had made the application or the order was passed that proviso to Rule 7, Sub-Rule 7 of Rule 9 of the SurfAC Act,
Surface.
provided that if after meeting the costs of removing encumbrances and contingencies, surplus available out of the money deposited by the purchaser, such surplus shall be paid.
The rules,
Rule 9.
Rule 9 of the surfacer rules makes it clear that after the amount, due amount is adjusted, the remaining amount has to be given to the borrower, has to be given to the borrower. It is submitted that when the applications are pending, when both the applications are filed, and without even having an order on that, without any basis, the petitioner plaintiff has come before the court and and in view of the interim orders passed by this court, the petitioner, the DDs were not delivered to the petitioner. Whatever the relief the petitioner is seeking from the court is an independent relief, and they cannot, the order that is passed by the court cannot be interfered with by this court. Anything else?
That's it.
Having heard the senior counsels on either side, peruse the material on record. The reliefs that are sought in the by the plaintiff are as follows. Extract the entire the relief in the plaint. That is at number 39, para number 14. The whole disputes revolves around what is that agreement?
Agreement is
Binding agreement.
binding agreement,
Page number?
page 22.
Around the
10/1/24.
agreement dated 4th Jan 2024, that is between the plaintiff and defendant number 1 to 3. In the said agreement, there is a mention about the fourth respondent and there are other the terms and conditions as per the said agreement. As the dispute arose with regard to the said agreement, the plaintiff has approached the court. It is as rightly submitted by the learned senior counsel appearing for the respondent. In the respondent defendant, in the general course, when an auction proceedings are initiated under the SurfAC Act, the bank has to, as per the procedure contemplated under section 9 of under rule 9 of the SurfAC rules, the amount has to be refunded. It has to be given after adjusting the expenses and the dues. That has to be given back to the borrower. But here is a case where a suit is filed for recovery of the amounts basing on an agreement, and the fourth respondent is a defendant. The fourth the bank is arrayed as fourth defendant, and the submission that the amount the defendant is entitled in the facts and circumstances, and in the light of the fact, in the light of the reliefs that are sought in the petition in the suit, this court is not able to appreciate the said submission. The defendant, as the plaintiff, has filed his objections on how the amount cannot be given to the defendant number 1 to 3, cannot be handed over to defendant number 3, and in the order impugned, there is no discussion with regard to that, why the objections of the defendant are not considered. However, in the interest of the parties, and right from 10/10/2025, the order is as this order is stated by this court, the amount is not so far refunded to the DD is not given to the defendant number 1 to 3. And balancing the interest of all the parties, this court is passing the following order. The writ petition is disposed of, directing the writ petition is disposed of uh, uh, by setting aside the order dated, the order dated so and so is set aside, and the matter is remanded back to the trial court. The trial court shall consider the IA number 1 filed by the defendant in the light of the objections filed by the plaintiff, and also the other two, the IA which is filed for under order 38 rule 5 within a period of 1 week from the date of receipt of the copy of the order, and it shall pass orders accordingly.
Please. This one indulgence can stop.
Yes.
The lordships have are remanding the matter. But on the merits, your lordships have made an observation. But I'll request your lordships may delete that from the portion of the order, because as to whether under the SURFACE Act, whether they are entitled to hold it, they could have made an application, because your lordships is asking the application to be reconsidered.
Yes.
So that portion of the order where your lordships have said, lordships may record the
This
contention,
Lord.
Yes.
but your lordships may say that the contentions are kept
I'll-
open. Otherwise, your lordships is deciding the case and remanding the matter. It doesn't happen that way.
Yes.
Lordships,
Yes.
please. Great.
Obliged.
I crave indulgence in one matter. Next matter.
We'll continue after lunch.
Since there's a matter listed for AG and Mr. Panendra.
I am but the
Yeah.
petitioner's.
You want adjournment?
Tomorrow, because some urgency
Because
also
tomorrow
is
it
there.
comes, then there is
Not
no
in this
chance to
week, no.
reach.
I'll
Today, at
take,
least
I'll take my,
after 2, 3 matters, it will reach.
no, no,
It
I'll
won't
come
take
at
time.
2:30 and take my chance. This is the next matter, that's why.
ಇಲ್ಲ ಮೆಮೋಸ್ ಹೋಗಿದೆ ಇವ್ರೆ.
ಮೇಡಮ್ ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ
ನಾಳೆ
ಆಗುತ್ತಾ?
ಇದೆಯಾ?
2:30
ಮತ್ತೆ
ಗೆ
date ಕೊಟ್ಟಿದ್ದ memo?
2:30 or 3.
ಮೆಮೋ ಪೋಸ್ಟ್ ಆಗಿಲ್ವಾ ಅದು? ಇವ್ರು ನೀವು ಫಾಲೋ ಅಪ್ ಮಾಡ್ಕೋಬೇಕು ಇವ್ರೆ. ನಿನ್ನೆ ಹೋಗಿ ಬ್ರಾಂಚ್ ಅಪ್ರೋಚ್ ಮಾಡ್ಬೇಕು.
ಸರಿ.
Madam,
ಏಳೆಂಟು ರೀಚ್ ಆಯ್ತು ನಿಮ್ಗೆ.
ಯಾರು ಜಾಯ್ನೇ ಆಗಿಲ್ವಾ? ಏನಪ್ಪ ವಿಷಯ? ಹಾ 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 ಹಾ. ಅಲ್ಲಪ್ಪ, ಮೇಡಮ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ತಗೊಂಡ್ರ ಅದು 2:30 ಅಂತ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಟೈಮ್ ಇದೆ. ಅದು ಹೇಳಿದ್ರೆ ನೀವು 2:30ಗೆ ಅಂತಾನೆ ಇದೆ. 2:30ಗೆ ಲಿಸ್ಟ್ ಹಾಕ್ಬೇಕಾಗುತ್ತೆ, ಅದಕ್ಕೆ ಹೇಳಿದ್ದು. 2:30 ಅಂತಿದೆ ಅಂತ ಹೇಳಿದ್ರ? 2:30ಗೆ ಅಂತ ಹೇಳ್ತೀಯಾ? ಹಾ ಸರಿ ಆಯ್ತು, ಡೈರೆಕ್ಷನ್ ಇದ್ಮೇಲೆ ಹಾಕ್ಸಿ, ನನ್ಗೆ ಯಾಕೆ? ನಾನು ಅದಕ್ಕೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಹೇಳಾದ್ಮೇಲೆ ಮುಗೀತದ್ದು. ಒಬ್ರಿಗೆ ಹೇಳಿದ್ರೆ ಆಯ್ತು. ಲಲಿತಾ, ಹಾ ಎಷ್ಟು ಮ್ಯಾಟ್ರ್ ಇದೆ? ಹಾ ಆಯ್ತು, ಇವಾಗ ಹಾಕಿ, ಅದು ಹಾಕಿ 2:30 ಅಂತಾನೆ ಮೆನ್ಷನ್ ಮಾಡಿ ಹಾಕಿ. ಅದು ಲಿಸ್ಟ್ ನಂಬರ್ 3 ನಲ್ಲಿ 2:30 ಇರ್ತಿರುತ್ತಾ? ಅವ್ರ ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಅಡ್ವೊಕೇಟ್ ಮೂವ್ ಮಾಡ್ಕೊತಾರೆ. ಯಾರು? ಹಾ 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 ಅದೇನೇ ಹೇಳೆ, ಹಂಗೆ ನೆಕ್ಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಮಾಡ್ಕೊಳಕ್ ಆಗಲ್ವಾ ಅಂತ. ಇವತ್ತಿನ ಲಿಸ್ಟ್ ಸೀನಿಯರ್ ಲಿಸ್ಟ್ 3 ಏನಿದೆ, ಫ್ರಮ್ ದಟ್ ಆನ್ವರ್ಡ್ಸ್ ನೀವು ಲಿಸ್ಟ್ ಮಾಡಕ್ ಪ್ರಾವಿಷನ್ ಇಲ್ವಾ? ಈಗ ಒಂದ್ ಕೆಲಸ ಮಾಡಿ, ಲಿಸ್ಟ್ 3 ನಲ್ಲಿ ಅಡಪ್ಟ್ ಮಾಡ್ಕೊಂಡು ಹೋಗಿ. ಲಿಸ್ಟ್ 2 ಕಂಪ್ಲೀಟ್ ಆದ ತಕ್ಷಣ ಲಿಸ್ಟ್ 3 ವಿಲ್ ಬಿಕಮ್ ಲಿಸ್ಟ್ 2. ಲಿಸ್ಟ್ 2 ಬಂದಾಗ ಬ್ಲಾಕ್ ಆಗುತ್ತಲ್ಲ, ಅದು ಲಿಸ್ಟ್ 2 ಬಂದಾಗ ನೆಕ್ಸ್ಟ್ ಲಿಸ್ಟ್ 2ಗೆ ಲಿಸ್ಟ್ ಬ್ಲಾಕ್ ಆಗುತ್ತಲ್ಲ. ಈಗ ಆಯ್ತು, ಇವತ್ತು ಪರ್ಸೆಂಟ್ ಈಗ ಆಯ್ತು. ಇವಾಗ ನಾಳೆಗೆ ಅದನ್ನೆಲ್ಲ ಲಿಸ್ಟ್ 3 ಮಾಡ್ಬಿಡಿ. ಆಯ್ತು, ಲಿಸ್ಟ್ 2 ಮಾಡ್ಬಿಡಿ. ಲಿಸ್ಟ್ 3 ಸೇರಿಸಿ ಇವತ್ತು ಉಳಿದಿದ್ದು ಸೇರಿಸಿ ನಾಳೆ ಲಿಸ್ಟ್ 3 ಮಾಡಿ. ಲಿಸ್ಟ್ 2 ಮಾಡಿ. ಲಿಸ್ಟ್ 3 ಹೊಸದಾಗಿ ಸೇರಿಸ್ಕೊಡಿ. ಏನ್ ಗೊತ್ತಪ್ಪ, ಅದೇನೆ ಇವಾಗ ನಾನು ಹೇಳಿದ್ದೀನಲ್ವಪ್ಪ. ಈಗ ಲಿಸ್ಟ್ 2 ನಲ್ಲಿ ಉಳಿದಿರೋ ಮ್ಯಾಟರ್ಸ್ ಅಂಡ್ ಲಿಸ್ಟ್ 3 ಮ್ಯಾಟರ್ಸ್ ಆಸ್ ಇಟ್ ಈಸ್. ಇವಾಗ ನಾಳೆಗೆ ಲಿಸ್ಟ್ 2 ಮಾಡ್ಬಿಡಿ. ಉಳಿದಿರೋದು ಲಿಸ್ಟ್ 3 ನಲ್ಲಿ ಇರೋದು ಲಿಸ್ಟ್ 2 ಸೇರಿಸಿ ಯು ಮೇಕ್ ಇಟ್ ಆಸ್ ಲಿಸ್ಟ್ 2. ಹಂಗೆ ಮಾಡಿ. ಇಫ್ ಇಟ್ ಈಸ್ ನಾಟ್ ನೋ ಪ್ರಾಬ್ಲಮ್ ಫಾರ್ ಯು ಅಂತಂದಾಗ ಆ ತರ ಕಂಟಿನ್ಯೂ ಮಾಡ್ಬಿಡಿ. ಎವ್ರಿ ಡೇ ಅದೇ ಆ ತರ. ಆಯ್ತಾಯ್ತು ಆಯ್ತು, ಹಂಗೆ ಮಾಡ್ಕೊಳ್ಳಿ. ಎವ್ರಿ ಡೇ ಯು ಫಾಲೋ ದಿ ಪ್ರೊಸೀಜರ್ಸ್ ಅಷ್ಟೇ. ಆಯ್ತು. ಏನಂತದು? Adjournments ಎಲ್ಲ ಕೊಡು. ಅದೆಲ್ಲ ಹಂಗೆ ಇರುತ್ತೆ list ಅಲ್ಲಿ. ನಾಳೆ ಪಕ್ಕ ಹೋಗ್ತದೆ.
If your lordship please, may I respectfully mention a fresh unlisted matter of severe clock-bound urgency. I invoke your lordship extraordinary protection in CRP 515 of 2026, my lordship. As we speak, my lordship, the execution forces are.
Lords, the petitioner has suffered an ex parte award passed by the arbitrator. Section 34 appeal is filed. Section 34 application, Lords, the notice is directed when we said that the execution is levied for enforcement of the award, and the spot sale is fixed for tomorrow, and the court seal is also fixed. Lords, I am only saying that let the sale be deferred, my lords, because my section 34 is there. If a third party rights gets, because I can understand, my lords, if it is a question of restitution, if it is inter partes the litigation, then restitution can happen. But if a third party right gets intervened, and if I were to eventually succeed in section 34, pardon, my lords, it's an ex parte award. Lords, may I kindly see page 55, my lords. Lords, this award, page number 54, on 5th of May 2023. At page 57, my lords, paragraph number 4, 5, and 6. Yes, my lords. My lords, 15843 of 2026. Lords, I'm sorry. I thought it was 70 minutes. So 70. ಅವ್ರಿಗೆ 17 ಇಟ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅವ್ರಿಗೆ. So,
pronunciation, my lord, we many a times 17 will say 70, 70 will say 70. Our fault.
Let's page number 55. At page 57, my lords. Lords, what is important is paragraph number 2. I just wanted to mention this, my lords. As on the date when these proceedings were initiated before the arbitrator, there were 3 other proceedings which were pending. The reason why I am submitting this, my lords, is paragraph number 2, your lords may kindly see. In pursuance to the constitution of the tribunal, the Bangalore issued a notice to the claimant to file a claim petition deposit. Yes, my lords, it is says addressee left return to sender. Notes what happened. I was occupying one property, notes a residential property. An order of eviction was passed, and I was evicted pursuant to an order of the court. Thereafterwards, I have shifted my residence, so I was not available in that place anymore. Even when the first notice was sent from the arbitrator, the notices come back saying that the addressee has left. But the reason why I am submitting this is, as on that date, my lords, when these proceedings were taking place, 2 other proceedings were pending where advocate was already representing the present party. So they never took notice to the advocate. But instead what they did was they make an application saying that let there be a paper publication. Lords, in that I was participating, my lords. So the lawyer was already representing in some of the matters. Had it been brought to our notice, we would have participated essentially. But para 4, my lords, your lords will find that there is an application filed. Lords, now after the attachment is made of my property in the execution proceedings, I have made statement is made, my lords, while filing this application under section 34 at page number 49. At para 9, my lords, at page 53. Yes, page 45 is the application. My lords, at page 53 is the affidavit supporting this application, my lords, paragraph number 9. So it was on 1/5/2026 we came to know. Lords, it is nobody's case that the signed copy 1/5/2026. Lords, it's nobody's case that the signed copy of the award has been sent to me. It is not come on record anywhere as of now. Now only, my lords, I am saying, my lords, let the attachment continue.
Lord, please look at, my lord, page 292. 92. Arbitrator was appointed, my lord, by consent of both the parties in 2022. For, my lord, he knows, my lord, that there is an arbitration. He doesn't appear. He is a tenant, my lord, who was not paid rent. 6 crore, my lord, 7 crores of rupees, my lord, is the arrears of rent. What he is, my lord, trying to do is 7 crores, my lord. He has not paid, my lord, as on 14 crores. No, 14 crores, I believe. He has not paid rents at all, my lord, for the last 5 years. And, my lord, we filed this petition at 292. He is aware of it. He does not come before the arbitrator. We, my lord, take out paper publication. And, my lord, in Kannada and English newspaper, he is aware of it, yet doesn't come. Award passed, my lord, in the year 2023. He, my lord, files this, my lord, in 2026. He is fully aware of it. It's not that, my lord, he does not want to pay, my lord. I can only say this. He has to deposit, my lord. He goes before the arbitration court. My lords are aware, my lord, this honorable court, honorable Supreme Court has time and again held. If, my lord, there is an award, you will have to deposit. He does not want to deposit the money. 14 crores, my lord. He has not paid rent, my lord, for the last 5 years. These are the judgments. All that I'm saying is, my lord, he has to, my lord, deposit, let him deposit the money. That's
I think
all. In
there is
court.
something which is a little short of instructions because I was never a tenant. It is not a case of tenancy or a
My lord,
landlord
please come
relationship.
to
Let me,
the agreement itself.
Lords,
The
this was
agreement is
never a
there.
case of, there was an application, I just point out, Lords, there were litigations prior to this arbitration. A suit for injunction was filed by me. Lords, this agreement is business participation agreement. In the business participation agreement, I was required to run a restaurant, and while running the restaurant, certain minimum amounts had to be paid to them. Lords, now, when the section 9, not that premises belongs to somebody else who is a landowner. Now, an injunction application, because once I took over this business to run the business, there was interference which was caused by the original landowner. They are the tenants. Then my application for injunction was rejected. On the objections filed by the person who had entitled me to carry on the business as also the landowner, my injunction application was rejected, saying that no, you are not in lawful possession, you are not in possession of the property.
I think
Then
actually-
they filed section 9.
Actually, my learned friend may not be correct. Injunction is granted in his favor.
No, injunction is rejected. I'll just read it, Pinots. Then section 9 application was filed by them. Section 9 application was dismissed on the ground of delay because the agreement is for a particular period. The time by virtue of which they had already filed the section 9 application, more than 4 years are already lapsed. So the section 9 application came to be dismissed only on the ground that it's a belated claim, it's a stale claim. Then they made an application before the CMP, Milords, that's before this honorable court, by which time the law was that this limitation has to be considered by the arbitrator himself. Lords, we said we have no difficulty, but we never received any notice. There were 2 other proceedings. Lords, may kindly have a look at that injunction order at page 161 because it's rejected. Page 161, Lords, may kindly see the prayer sought for. In the suit which was filed by this landowner, Navita is the landowner. And if your lords were to see, Chitra Panikar and Sunil Panikar They are the defendants in that suit. A. Narsimhan is the second defendant there. Lordship gets it, it's in the cause title. Then next one, next page 162. Applicant defendant number 2 has filed an application order 39 rule for temporary injunction restraining plaintiff or anybody interfering with the peaceful possession and enjoyment of defendant number 2 or the property. Now your lordship may kindly see at page number 168, application is rejected by imposing cost, saying that we are not in possession. Because even the stand which is taken by them throughout is that the it is only permitting the, kindly have a look at page number 159. First defendant filed the objections to this application. To the application saying that my possession should not be interfered with. Lords, yes. The para 2, my lords. The defendant submits that second defendant is seeking to invoke the equitable relief of injunction without performing his obligations to the business participation agreement of 1/7/2015. Relief of injunction being equitable cannot be granted. Well, this business, that is the what is subject matter of the arbitration proceedings. This business performance agreement or the business participation agreement is what is subject matter of the arbitration proceedings. Their contention is that I was liable to pay certain amounts under the business participation agreement. There is no question of lease. This is essentially what I am not saying that my property, even according to them, they have filed the valuation, it will cover their decretal amount. If section 34 code feels that my application is belated or dismissed, I don't stand a chance. Now that my learned friend is before the court, we moved the application, that is the order impugned, my lords, before your lordships. Lords, now let them take notice. Within a period of 2 weeks, let them decide the matter as to whether I am entitled for the relief or not. If I am not entitled to relief, my lords, let the attachment continue. So that their entire claim is secured. Please, my lords, the page number 20 minutes is the order impugned. It's an application under 36(2) and 3. No reasons are assigned, my lords. Para 22, it only says that heard and perused materials, without hearing the other side, it will not be proper to pass an ex parte order. That's the only reasoning which is given at page 22. Lords, I am not saying, my lords, that if ultimately there is an lords, operative portion of the award is at page number 75. Lords, as a matter of fact, as on the date when the award is passed, the ejectment suit which was filed by the landowner had already been decreed and they had already taken possession of the property by means of an execution proceedings. That's the reason why I said, my lords, the whatever has been placed before the arbitrator is the materials which was placed by them. The arbitrator was not made aware of the fact that there were anterior litigations where even the landowner had already filed a suit for ejectment. There were inter se litigations between us. There was a litigation between the landowner and the tenant where I was also made as a party defendant. There were multiple orders which were passed there. Nothing is brought to the notice. That is the reason why I brought your lordship's notice, my lords. Page number 161, my application was rejected.
My lord, can I request your lord to look at page 61, my lord? My learned friend is not correct. He is absolutely not instructed properly. That's all I can say. He files a suit. Narasimhan is, my lord, my learned friend appears. He files a suit. 61. Statement of objections, my lord. Sorry, my apologies. Yes. Please come to page 61. He files a suit restraining, my lord, against, my lord, the respondents before your lordships. Please come to, my lord, running page 85. Yes. Please come to 85. Operative portion of the final order. Suit is decreed. Defendants are restrained from permanent injunction from dispossessing the plaintiff. 85, my lord. My learned friend was reading, my lord, some other thing. It is a criminal case.
No, it's a original
One
suit for
minute.
ejectment which
I'll
was
just,
filed.
let me say what I want to say, please.
It's not a criminal case. It's OS.
Please come to my lord page 149. This is my lord the decree in his favor. Please come to 149. My learned friend was reading 161. Please see my lord, what is it? It's a criminal case. CC number 55130 of 2017. If your lordship sees my lord page 150, complainant claims to be the proprietrix, agreement, etc., my lord, and criminal case. Please come to my lord, running page 176. Yes, yes, but then please come to my lord page 176, operative portion. My learned friend doesn't want to read all that. Acting under, my lord, it's a negotiable instruments act, my lord, there is a check we issued, my lord, which got dishonored. Acting under section 255, accused is convicted, that him, of my lord, offense punishable under 150, 138, the negotiable instruments act. Accused is sentenced to pay a sum of rupees 5,55,000. This is what he was reading. My submission to your lordship.
No, there is
I
some
think you know,
mistake.
permit me to
My
say
lords.
what I want to say when you
No,
argued. I did not
lords,
even open my mouth, my lord.
I'm only
My learned
correcting
friend
my
must
learned
have, my lord,
senior
some, my
friend.
lord, courtesy. Let me
What
say,
I
my lord,
read,
what I want to say. He does not want me to even open my mouth.
so I wanted
Naturally,
to
my lord,
correct my
because
learned senior
please
friend
look
that
at, my
what
lord,
I read
look
is
at, my
page
lord, the award
161 of
passed.
my petition,
Please come to
not
my
of his statement of objection.
Please come to my lord award. My lords may come to my lord the award, which is my lord in the main my lord petition. Please come to my lord the award. Page 75. Seven five, my lord. Claim petition stands allowed, my petition. Business participation agreement dated between so and so stands terminated. Claimant is entitled to possession, my lord. Arbitrator says, now I am entitled to possession because he had obtained an injunction. Except due process of law. And my lord, we went before the arbitrator. My lord, the order passed by your lordship, my lord, in 2022. He is aware of it. He was a party there. Justice Adi, my lord, Subhas Adi, my lord, our former judge of this honorable court, is appointed. He deliberately does not come because, my lord, he has to pay, my lord, 14 crores rent for the first 5 years. He is in possession. Therefore, my lord, page 75, third line, serial number 3. Claimant is entitled, I am entitled to possession of the scheduled property. And, my lord, he was directed to pay 6 crores, 92 lakhs, my lord, as on that day, with interest from 1/6/2015. 14 crores is amount due. He has to deposit something. He, my lord, what he can't do, my lord, he went before the 34. He has to deposit. This honorable court, honorable Supreme Court has time and again held, if there's an award, my lord, he has to deposit money claim. Does not want to do it. 5 years, my lord, he has harassed the life out of us. We also, my lord, have to pay, my lord, landlord. We have been paying the main less, my lord. I am the tenant. He is the subtenant. Therefore, my lord, he has to, my lord, he can't have the cake and eat it too, my lord, is all that I would say. This honorable court, my lord, has specifically held 100% of the amount should be deposited. I will let kept, my lord, some judgment for my lords. Not that, my lord, your lordship doesn't know. Your lordships are fully aware of, my lord, and all the. In fact, 274 of the objection statement, my lord, if your lordship take. In fact, they are continuing to be in possession, is, my lord, recorded by this honorable court in an RFA. 274, my lord, this is in RFA 1628 of 2024. My lord sees, my lord, Chitra Panikar is the respondent. If my lords come to my lord, Navita, my lord, is the second respondent. Please come to my lord page in the same, my lord, order of 27-4. Last, my lord, 10 lines. It is admitted. Second respondent is in possession of the property at present. Though notice is taken out to the second respondent is held sufficient, there is no representation. He does not come there. He does not come before the arbitrator. He does not, my lord, because, my lord, he has to deposit.
Lord says, I am making a statement that even according to them, the property which has been attached is more than the value which they seek to recover. Otherwise also, I don't have anything else. It's the only property which is with me. I'm making a statement, let the property attachment, Lords, let the attachment of the property may continue. The Lordship is giving me a window of 15 days to 20 days. If I don't succeed, I lose my property and they will get the money. It's essentially where it stands. One chance is what I'm asking. It's been an ex parte award. One chance is what I'm asking, Lords. If the section 34 court feels that nothing is there, then there is nothing much which I can do. Lords, now whatever, Lords, Lords, I am as a party to the, Lords, now, after the arbitrator is appointed, there is a requirement of a notice being issued. Notice was never issued to us. Lords, had a notice been issued, Lords, that is the reason why I said, now, what was brought to your Lordship's notice is that there were other proceedings. There was a check bouncing case which was filed. Lords, I fully agree, my lord, that this should have been done. If there is a failure, even if there is a failure on his part, my lords, I am in a position to demonstrate that I deserve one chance at least under section 34 to convince. Lords, now if the attachment order in force is in force for the next 2 or 2
Property
weeks.
is worth 4 crores, 14 crores the amount due.
Now-
And every day, my lord, it is recurring because possession was ordered. He still continues to be in possession, enjoying.
My lords, if
2.5
that's
lakhs,
a
my lord.
statement which he is making, my lords, if my learned senior friend is making that statement, let it be recorded that I am in possession of the property. Because that's not factually correct. We are not in possession of the property. Your lordships may appoint a commissioner at my cost. Now he has already taken possession of the property, the landowner, by filing a suit for ejectment against them. I can produce that ejectment decree. Lords, I am not in possession of the property. It was a business participation agreement where I had to. Lords, property belongs to the same page 161, my lords, of my petition. That is annexure L to my writ petition, which I read. This is the petition, my lords, where it belongs to Navita M. So now, Navita is not a party to the arbitration proceedings. In that suit which she had filed, Lord, this is what was said. I just want to, there is some. From me, because the finding is recorded, my lord, saying that, my lords, in the suit which was filed by. I have, my lords, I am making a statement so far as that operative portion which your lordships have seen at page number 75, that is serial numbers, serial number 3 and 5. My lords, I am not seeking for any stay, my lords. I am not challenging that portion of the order at all. 3 and 5. As a matter of fact, in 23, the page 75. 2, 3 and 5. 2, 3 and 5. I have no qualms over this.
Three and 5 also.
Yes.
Claimant is entitled for recovery of an amount of rupees.
Lord,
No.
so far as 4 is concerned, my lords, that's the reason why I said, now this is challenged. I'm not saying, my lord, that I got an
How
absolute
they have
case.
initiated the proceedings now?
Now
for
he has
free of this
initiated
money.
execution proceedings. Lords, he has initiated only execution proceedings.
Hmm.
For the purpose of recovery of the money, not for possession.
Now,
Just-
what are they doing?
Pardon me, lords?
What are they doing?
Now the property is attached. I have no objection.
Property.
Lords,
That property we are not
not this
concerned.
property, my personal property. I have a residential house in Jayanagar. That property, it's a residential construction in a property measuring 40 into 60 feet. That property is brought under attachment. I have no difficulty, my lords, for the attachment to continue. Now, the property is now proclaimed for sale for the spot action to take place tomorrow. Lords, I want only a chance because section 34, I have said that this is the reason where I have not been notified in the arbitration proceedings. 34 may or may not agree. But in the intragnum, my lords, if third party rights are intervened, then I have nothing.
The
I
amount
can't
is-
even seek for restitution under 144.
In any of the matters where an order with regard to the money is concerned, we will be granted. To consider it, we will be granting it only on the condition.
Lords, that's the reason why I said, my lords, your lordships will grant if I am in a position, now if it is an unsecured debt. Now if it's a mortgage debt, then such directions will not be given because mortgage property is always there. Now here is also a case where the property stands secured because there is an order of attachment, my lords. The property stands secured.
How long it will go?
15 days or 20 days, your lordships may fix to consider my application, which the court says that it will not be considered ex parte. It will be considered after hearing the parties. If this application is considered within 20 days, I stand a chance or I don't stand a chance. But till such time, my lords, the sale may be deferred is what I am submitting.
Once it is deferred, now that order again is set in appeal.
Lords,
And
now,
that goes on.
no, my lords, what happens thereafterwards is the court will have to only reschedule the dates. If your lordships were to pass an order that it should reschedule the dates depending on the result of this application, they will only reschedule the dates. There is no question of any fresh process. They will only reschedule the date saying that the court sale will be on so and so date. the spot sale will be on so and so date and court sale will be on so and so date. That's all what is required to be done, my lords.
274, second respondent is him, he's in possession, is what, my lord, is recorded by this honorable court.
So I'm not a party
The
there. This is a,
And
no, I just
Not-
point out, my lords, because
he, my lord, says his property is attached. In fact, my lord, the Bombay High Court, my lord, which matter went before the Supreme Court, ordered, my lord, bank guarantees. Supreme Court said, no, you'll have to deposit the money. That's what, my lord, it is. And this honorable court has held. Justice, my lord, Chief Justice Court, my lord, in another matter, has held recently. They'll have to deposit. They can't, my lord, what they couldn't do directly, they are trying to do, my lord, indirectly. That, my lord, can't be.
lords, that RFA page 274, what my learned friend is referring to, my lords, is a suit. This is filed by Chitra Panikar against the ejectment suit which was filed against them. Navita M. my lords is the respondent in that. I am not a party to those proceedings
Second
formally.
respondent is him, my
I will
lord.
just, because without, my lords, I am not even notified in those proceedings.
Your name is Chitra?
My lords, Chitra Panikar is,
Oh, no, Vishwanath. Where
No.
is the name of Vishwanath in that?
no.
Where is that
Narasimha, my lords, my,
Respondent, my lord, is him.
no, Narasimha, lordships, I'll say that, to my, lords, we have not participated in these proceedings. This has come up.
Naturally, my lord, they won't
Lords,
participate there,
it
they
is-
won't participate in the
My
arbitration.
lords,
they won't
I
participate.
wanted to say this, that there is no liability to make any deposits in this. Here is a case where there is an ejectment decree which is probably under consideration between the landlord and the tenant. He is the tenant. I am not claiming to be a tenant at all, or nor am I claiming to be a subtenant. In that dispute, my lord, certain observations are made, is what is sought to be read over to your lordships. I am making a statement that so far as 1, 2 and 4 is concerned, I am not seeking for stay, nor did they file any petition for execution of this part of the award. They never said that I am in possession of the property for,
We'll consider your request, deposit some amount.
lords, my property itself is there, my lords. I am making a statement that let the property's attachment may continue, my lords.
It's just 4 crores, it says.
My lords, that is the valuation, my lords, in Jayanagar, my lords, 60-40 will never be, my lords, 35-40,000 rupees is the square feet value. If they permit me to sell, I can sell it at 10 crores to 12 crores. That's not the question. It can, who will get a property at 4 crores in Jayanagar, 60-40 with a residential construction? Can't say. It's one of the most premium localities in this city, my lords.
Fact, Jayanagar, my lord, the value is only 4 crores.
This is the problem, my lords. Yes, similar to what happens even in the SARFAESI proceedings when this is distress sale. So valuation can be anything. But I'm making a statement, let it be there. If section 34 court feels that I'm not entitled for any indulgence, then I'm back, my lords.
Let him deposit, my lord, I have no problem.
My hands were,
Normal rule is 100%. Let him deposit even 50%. That also he does not a rupee, my lord, 5 years. In fact, my lord, we paid, my lord, to the landowner. We have gone on paying. Recently, my lord, in the RFA, we deposited 80 lakhs, my lord, which the landlord.
Get instructions from
Yes.
that line. If he's,
lords, tomorrow is the court auction.
if he's ready to pay some amount, then only we'll interfere with that. Because the conduct of the party is also important. That also we have to consider.
Very well, my lords. Lords may, but tomorrow, my lords, if the spot sale takes place. my
No,
lords.
let him get instructions. I'll, at end of the list also. I can-
Very well, my lords, please. So grateful for your lordship's indulgence.
Next.
List number 3, serial number 76.
Lord, in this matter, I'm appearing for petitioner. So Lord, this honorable court had directed me to file an affidavit in this matter. They had filed the affidavit. My Lord, to my affidavit, my Lord, a rejoinder is filed by them. Yesterday, they have served a copy, my Lord, along with a bunch of, my Lord, documents. Let me just take instructions. Could it be had on Monday, my Lord? Only requesting time till Monday. Since they served to
Very
me on
strange
yesterday.
matter.
We should have served it much before. Last time when the matter came up, it is said that
Yes.
they'll be served.
This is a very strange matter. He comes before the court on one occasion saying, because of COVID, I lost out certain period, extend the lease period. That was done. Then the court gave us
What is
liberty.
the affidavit filed by him? Let's see.
Please see the affidavit, my lords.
Dated
And only one petitioner files an affidavit on 1/6/2026.
1/6/2020.
There are two petitioners. They started claiming suddenly, my lords, hereditary rights.
It's 1/6 or 10/6?
Lords, it's date for us, it's 1/6, my lords.
Memo filed. by
1st
the-
of June, affidavit.
Memo filed with the petitioner pursuant to the order of the court dated 2/6/2025. 25. What is this?
Once,
20215.
it is 25004. Case status.
Affidavit, yes. Who are the petitioners?
Lords,
Hema and,
Hema and Rangaraju.
that's husband.
No,
Hmm.
not related. Lords, the first issue was they were granted permission, my lords, to distribute certain prasad and other items.
My lord, at para 2, my lord, this honorable court had directed, my lord,
Lords, what happened, Lords, was I pointed out to my lords to indicate in 2003.
Representation.
They made a representation where they claimed that they are
Unemployed.
uneducated and without any work, kindly give them money. So subsequently, they came out with this fresh thing to say that hereditary. For that, my lords had given this direction.
Yes.
To say that they have to answer whether they had made that representation and what about their representation. To answer to that, my lords will find it at page number 3, para number 6. They wouldn't answer that. They will only para number 6 minutes.
So, paragraph number 2, Mr. Counsel.
yes, please.
Paragraph number 2.
Yes, please.
From which year the petition is exercising the rights of preparation of prasadam and selling the same. For that, what was the answer? Which paragraph?
My lord, para 3, my lord.
What did you say?
Petitioner belongs to family of Sri Adi Narayanappa, who is the grandfather of petitioner number 2. Sri Adi Narayanappa was a hereditary paricharak in the Ghati Sri Subramanya Swami
When was the
temple.
representation by you to the
Close to-
temple?
My lord, para 4, my lord, they themselves have passed a resolution that
When
I have
was-
stated.
When was it?
My lord, 16/1/1984, my lord, they have passed a resolution
Hmm.
permitting me, my lord, for sale of prasada items.
84, he was not even in the picture.
Please see,
Please
no,
see
I'm
it.
just
Please
narrating, my
read
lord, what
forward.
I have stated in my affidavit. With regard to, my lord, the representation, my lord,
Who is Adnarayanappa?
he is the, my lord, grandfather of petitioner number 2.
That even he was not conferred with hereditary right.
My lord, what I am requesting, my lord, is this. Now that, my lord, yesterday they have filed, my lord, served a copy to me.
But I'll tell
With the
you,
rejoinder, let me just take
your-
instructions, my
your,
lord.
Your client is unnecessarily coming into this, purchasing this trouble by filing all this. All the more affidavits you file,
My lord, they have filed a rejoinder.
you'll
my
land
lord.
up
I'll
in
just-
trouble.
They have an interim
just
order
take
benefit. So, my lords, the temple today for only 2 items is earning about 1,10,000. They, my lords, without anything, they're carrying on the business. They would just want to control because of an interim order. Please see the main prayer.
What was the temple doing and the state doing?
My lords, that is why we have filed, my lord. Please see the first writ petition which was filed by them.
This is a writ petition of 2023.
Yes, my lords. Absolutely. The state was there. Now there is an act brought about for the management of the temple itself. Under that, my lords, there can't be any rights given to any private person, my lords. That is also brought on record. It's here.
Anything has to be by way of auction.
Yes.
Any property,
If,
any-
and
any-
today,
any-
my lords, the prasad, my lords, under the act is to be distributed only by the temple. It's just like how it is done in Tirupati and other temples, Kukke Subramanya or any temple, my lords. The distribution of prasad is not outsourced.
And it is not production of anything rather than preparing anything. It is rock sugar, which is kallu sakare called in Kannada, as well as dates, lords, dry dates. That is the prasad specifically for this temple. So the question of preparation as claimed by them wouldn't come at all. Lords. There is no preparation of any prasada, especially these two, which is done by them.
And
It is
if we
procured
had-
in the market.
If he had to
and
claim
distributed.
hereditary rights in the earlier writ petition, my
Oh,
lords, which your lordships have got.
I'll take up this matter day after tomorrow at 2:30. And I'm
May I request on
indicating,
Monday?
no, I'm indicating it. Please advise your client. If he is withdrawing this writ petition, that would be in his interest. Or else we have to go into all this and he would be put to further trouble. Please tell him.
May I request it on Monday, my lord? Could I take
Monday,
it?
2:30.
Please.
This matter, Monday, 2:30. And that day, once the court takes a decision, there is no question of going back. That you please tell your client.
Interim order may kindly be extended.
Interim order is extended. Call it 2:30 on Monday.
Obliged.
21 in the third list. Yes.
Cell number 21, list number 3, 230 more.
I appear for the petitioner.
Jay Kumar.
My lord, this is a matter where the award is against a company. However, the director's personal assets are being sought after. My lord, I'll just take my lords through the operative portion of the award at page 71.
Where is this order dated 24/4/2026?
My lords, annexure A,
Page number.
page number 27, my lords. Page 27 of the writ memorandum.
27 or 37?
27, my lords, 27. That's- If I may read, third paragraph, my lords, counsel for Mr. Tara Prasad Mohapatra is present and submits that he has furnished all relevant informations to the best to his knowledge and ability and undertakes to keep Tara Prasad Mohapatra so that the other side counsel can conduct inquiry. My lords, still here I have no difficulty. It was my submission. With regard to the assets of the said person is where I have an issue, my lord. The application was also for the assets of the judgment debtor company, which I have disclosed to the best of my knowledge and ability.
What is the order?
Look, the order is that inquiry will be conducted with respect to my personal assets.
That you can tell the court that you cannot conduct.
Please, that was my case, my lords.
That's what, no, nothing, no order is passed. Why should we interfere now?
My lord, this is the order. To this effect, if it's not set aside, then the executing court will permit the decree holder to inquire about my personal assets, my lords. When the debt is against when the award is against the company.
Very sad.
My lord, last line, my lord, Mr. Tara Prasad Mohapatra, so that the other side counsel can conduct inquiry with regard to the assets of the said person. Lord, the inquiry can.
Who is Tara Prasad Mohapatra?
Tara Prasad Mohapatra is the petitioner here in my lord.
Yes.
He is also a director of the judgment debtor company. However, the executing court has directed that there must be an inquiry with respect to my personal assets as well for the debts of the company.
That is your counsel has submitted.
I am for Tara Prasad Mohapatra.
That's what. Counsel
No.
for Mr. Tara Prasad. Read it.
Please, my lord, I agree, but I didn't submit that with regard to the assets of the said person. You want to conduct an inquiry with regard to the assets of the company, my lords. I have no difficulty.
That is the submission
No,
recorded.
I'm only the counsel appearing, my lord. This was not my submission.
You should have informed the court that it is not, what is recorded is not correct.
My lord, I've come before this court. If I go before the trial court will say it's already
It
given a
says
finding.
Counsel for Mr. Tara Prasad Mohapatra is present and
Please.
submits that he has furnished all relevant information to the, what has been submitted by you has been again reproduced in the order. You say that it is an order now which has to be set aside.
My lord, that is not my submission. I submitted, I have.
Clarification sitting here, the court cannot decide that. That the trial court which has recorded this order, which is not your submission, would decide it. Go before the court. We can't. I cannot go into this aspect.
And my
Please
lord,
come.
kindly grant me liberty to challenge the order. Please.
The petitioner is agreed by an order dated 24/4/2026, whereby the court recording the submission of the counsel for the petitioner. Court has recorded the submission of the counsel for the petitioner that he has furnished all relevant information to the best of his knowledge and ability, and also undertakes to keep present the petitioner so that the other side counsel can conduct inquiry with regard to the assets of the said person. When counsel for the petitioner submits that the decree is against the company and they cannot proceed against the properties of the directors, and it is not permissible. Hence, the order needs to be set aside. Having heard the counsel for the petitioner, what is the order passed by the court? This court is not able to appreciate the submission made by the petitioner. In the order that is impugned herein, the court has only recorded with regard to the submissions that are made on behalf of the counsel for the petitioner. Except that no other order is passed. If, according to the petitioner, such a submission is not made by the counsel for the petitioner, then that could be brought to the notice of the court by way of an appropriate memo application, and the court would consider the same. This court cannot consider such a plea that though it is not submitted, court has recorded. In that view of the matter, this court do not find any reasons to interfere. Accordingly, this court is passing the following order: that a petition is disposed of, giving liberty to the petitioner to assail the order dated 24/4/2026. To bring to the notice of the court the order dated 24/4/2026 and all the submissions that were made before the court. The petition is at liberty to do so before the court.
Fellows, observations in the order may not.
I have not made any observation. I have only said that is what it is.
Please.
Yes.
Continuation of the list number 2, CL number 2. Yay, Shekhar Gowda.
Hearing for respondent.
Where is the other side?
Yay, Shekhar Gowda.
Yes. Yes.
My lord, I have challenged the order of the trial court. Annexure, my lord. As my lord, this honorable court in the writ petition directed the trial court to frame issues regarding on my memo and my application IN number 2 and as well as valuation slip filed by the plaintiff. I am the defendant therein, my lord. Now, my lord, I sincerely take your lordship to Inc. page 64 valuation slip.
What is the suit for?
Suit for, my lord, declaration and mandatory injunction. Declaration that, my lord, kindly see the prayer in page number. Plaint page number, my lord.
Yes.
Plaint page number 60, my lord. 60. Filed by a, my lord, a stranger seeking, my lord, a road 15 feet into 200 feet road in the conversion land of my land without there being any right title, interest or anything, and there is no document to show.
That's
my lord.
Schedule B property is meant for utility purpose.
Yes.
Ingress and egress of the plaintiff. Grant mandatory injunction directing the
Yes,
defendant to remove the construction.
And a permanent injunction. Now, I request my lordship to go to Inc. page 64, my lord, valuation slip. And a typed copy, my lord, 66, my lord. Please, my lord.
Yes.
So, subject matter of the suit is not at all valued, my lord. Though he sought 3 reliefs, judgment and degree of declaration, declaring Schedule B property is meant for utility purpose, ingress and egress of plaintiff and the users by.
What is the extent?
My lord, 15 feet into, my lord, Schedule B, 15, west to east to west 15 feet, north to south 200 feet.
Yes, that is one aspect with regard to the court fee.
Yes, my
What
lord.
is the other one? Jurisdiction of the court.
Jurisdiction. My lord, can you see, when valuation slip or the plaint, body of the plaint, said which court is having jurisdiction, whether territorial or pecuniary jurisdiction. My lord, kindly see the valuation slip, my lord. Therefore, your lordship said in this honorable court, ILR 2015 Karnataka 3554. My lord, that lordship clearly said how to value the suit, what to pay the court fee, and what provisions of case as we act to pay the court.
How it was decided by the court?
Now, my lord, can you see the valuation slip?
I've seen it.
Serial number 1, my lord.
Yes, 66.
1. Serial number 2, not applicable. Jurisdiction of the court, for the purpose of jurisdiction of the court, my lord, it is It has to be valued, the suit. Nothing has been valued. Serial number 4, my lord, can you see? The suit is one for declaration, mandatory injunction, and also for permanent injunction against the dependents.
Valuation slip is at page 66.
My lord,
Valuation slip is at page 66.
no value has been made.
That's what I'm saying. There is only one with regard to rupees 75.
75, on what basis he paid?
Yes, please come to the order. We will read what.
My
the
lord,
court
can you
said.
see? The learned judge of the trial court very erroneously passed the order. Your lordship can you see, after framing of these issues and put 3, 4, 5 issues number 3, 4, 5 as preliminary issues. My lord, without looking into the defense of the dependents, the petitioners, and what we made para 4, 5, 6 of the written statement, and the memos and IA are 710 CPC. Therefore, my lord, this honorable court was pleased to direct the trial court to frame issues and decide the jurisdiction first. Now, my lord, can you see the reasons? I would like to take my lordship to page number 41, reasons. Issue number 3. Since all 3 issues, 1, 2, 3, 3 issues are closely interrelated and interconnected, they are being considered together for the purpose of adjudication. There are 7, my lord. Upon perusal of the pleadings and documents submitted by both parties, it is not in dispute that plaintiff is the owner of the land bearing survey number 33/2A measuring, in new survey number 33/3 measuring 3 guntas. It is also incorrect, my lord. It is 2.12 guntas. And the dependents are the owners of the land bearing survey number 35/3, 35/4. The plaintiff is claiming an easementary right. At this stage, my lord, kindly consider my request. My lord, kindly go to plaint. Nowhere, my lord, he has not whispered anything regarding easementary right. First time, my lord, to my application at 710, my lord, they taken contention in their objections in page number 74, stating that they have got easementary right. There is no road at all at any point of time. It is in a converted land of 16 guntas. There is no road at all. My property 16 guntas is fully developed land. Still, my lord, the trial court come to the conclusion this.
I have read the order.
Please, my lord, please, my lord. Now, my lord, since the suit has not been valued, which court is having jurisdiction to try the matter, is still expressed. Then, my lord, the trial court, I would like to take my lordship to para 14.
I have read that paragraph number 14. You can
14.
submit.
In the context of the present case, the decision supports the plaintiff's stand. If your lordship to take consideration of these 2 lines, my lord, kindly go to para 12, in page 43. At this juncture, it is relevant to refer the principle laid down by the Honorable High Court of Karnataka in the case of B. Krishnappa versus Chandrika G. reported 2007-1 KLJ, particularly of paragraph 17. It is not at all applicable to the present situation of the case.
Judgment you're relying on. Like, I understood the facts. What is law on that? What are you relying on? If you can pass on the judgments, I will go through that.
No, the trial court referred.
I've seen the order and the judgment is not applicable, then how
Trial
it
court
has to be
referred. I will
valued?
read,
What
madam.
is the law on that?
I will read, my lord, please.
I've read that. I've read the order. You can only make submissions on
Please.
that.
Now, my lord, jurisdiction has to be decided first.
Yes.
According to section 9 and 21 or section 6 of the CPC. Here, my lord, the trial court, erred in, my lord, coming to conclusion that in order, the suit filed by the plaintiff is maintainable before this court. The plaintiff has purposely, properly valued the suit.
Court is of the view that he sought for only easementary right and the suit is maintainable before the court and the court is having the jurisdiction. He has paid the court fee under section 24D or so and so.
It is not applicable, my lord, because suit, subject matter of the suit itself is not mentioned. My lord, kindly go to page number 64, valuation slip.
Understood your submissions.
Therefore, my lord,
Appreciate
kindly
that.
remand the
I'm
matter.
asking you, are you relying on any judgment? You have any judgment in your favor?
Which judgment, my lord?
You're relying on any judgment of this court or the apex court in support of your case?
Yes, my lord, I have got many rulings.
Where are they?
I have not brought today. My lord, kindly see the simple matter. Anybody, my lord, it is the duty of the solicitor of that court to verify the valuation slip. When it is not there, therefore, my lord, kindly remand the matter to the trial court for approach disposal.
Submission, my lords. Matter requires small consideration, small point required.
The
my lords.
value of
According
the-
to the section 30 of Karnataka Court Fee Act, my lords, for a moment your lordship may take section 30, Karnataka Court Fee Act.
It is not applicable. You have not
It is
sought for
applicable.
easement right.
Let him argue.
Please,
Section, sir.
section 30.
Yes.
When it's suits relating to easements, it is very much clear. In a suit relating to an easement, whether by the dominant or the servient owner, fee shall be computed on the amount at which the relief sought is valued in the plaint, which amount shall in no case be less than rupees 1,000. Rightly, my lords, I am not a stranger to the case as they have contended. I am the younger brother of petitioner. Schedule A property is gifted to me by our father. Schedule B property, my lords, your lordship may see page 61 for a moment. Schedule B is all the part and parcel of the passage road measuring east to west 15 feet and north to south 200 feet, running on the middle of the properties bearing survey number 35/3 and 35/4, which is the property of the petitioner, and the Schedule A property, which is gifted by me, our father. In the gift deed, my lords, of 2018, in the boundary towards the west, the road is mentioned, and the petitioner is the consenting witness to that. This was all before undisputed point of time. I have filed the suit for easementary rights and mandatory injunction and also permanent injunction. Mandatory injunction because upon that road, the petitioner started constructing the hollow blocks. That temporary injunction was granted. That was upheld in the MA and also in the writ petition before this honorable court. Rightfully, I have valued the suit as per section 24D, 26C and section 30 of the Karnataka Court Fees Act, which is 25 rupees comes to 75 rupees. The trial court has rightly held that. Your lordship may see the reasoning.
I've seen.
Please, my lords. When such being the case, his contention is only that I am asking ownership and possession on that road, which is absolutely wrong, my lords. I am asking only a easement right for ingress and egress to reach to my property, which is backside of the road. Such being the case, trial court has rightly upheld the contention on issue number 3, 4, 5. That is whether the court fee is paid properly and the suit is been maintained before the junior division court. I am the master of the suit. I have rightly pleaded that it is suit for easementary and mandatory injunction, and I paid the proper court fee, my lords.
Yes, what is on next?
No, my lord. The relief sought in the plaint, my lord, it will not attract the section 30. There is no whispering of any easementary right. My lord, this 3,000 square feet of
I have mentioned about the easementary right in the pleadings.
My lord, 1,92,45,000. That is the land value. There is no road at all. Now, I would like to take my lordship, 1 minute, please, my lord. My petition book, I would like to invite my lordship to in page 52, release date, gift deed. Schedule ಬನ್ನಿ ಪಶ್ಚಿಮಕ್ಕೆ
Please.
ಸ್ವಲ್ಪ ನೋಡಿ ದಯಮಾಡಿ ಪಶ್ಚಿಮಕ್ಕೆ ವೈನಾರಾಯಣ ಸ್ವಾಮಿ ಆದ ನಿಮ್ಮದೇ ಜಮೀನು ಅಂದ್ರೆ ಇವ್ರ ಜಮೀನು ಅದಾದ್ಮೇಲೆ ನನ್ನ ಜಮೀನು ರೋಡ್ ಎಲ್ಲಿದೆ? My friend is misleading that in middle of my land there is no road at all.
200 into 15
Now,
feet, there is mentioned.
No, my lord, at the same time, your lordship may kindly say, this Yellappa, you have no right to convey the alleged road which is not in existing at any point of time. That is my cry before the honorable trial court. Ilde road anna illinda tandukododu elli ಮಾಡ್ತಾರೆ ಅವರು ಅಂತ. Then my lord kindly go to schedule A property in page 61 of the plaint. East by Amani Utturkere, west by east to west 15 feet and not to south 20 feet road ಅಂತ ಕೊಡ್ತಾರೆ. ತಪ್ಪಾಗಿ ಕೊಡ್ತಾರೆ. Wrongly given. Therefore, I would invite my lordship to GIP deed for the year 2018, ink page 52, my lord. How they are very conveniently giving boundaries when there is no road at all. My lord, I am the elder brother, he is the younger brother. It is not the criteria. My portion of property is separate and his portion of property is separate. He had 3 roads to the, for the egress and ingress. On very adamantly, my lord, you want to, my lord, divide my property 16 guntas. I don't know how, what is his intention.
Yes, or reserve. Next.
Number 3.
Okay.
Yes.
Number 3. Reserves. BBC. Chokuma for petition.
I will publish citation. Yes, go on,
Ah,
Doctor.
you can.
Please.
That an application under 32 Rule 15 was allowed in the petition, as against which the defendants are before the court. But the contention that was raised was that one Narasimha Reddy, the application that was filed by his wife alleging that he is mentally unsound and he is suffering from schizophrenia. That's our contention. But we opposed on the ground, saying that he is capable of speaking and he can conduct the case by himself. Not an inquiry was conducted
This
with
is suit for?
suit for partition. Partition by him as against his brother and mother and sister. That's the suit that came to be filed. But there was already a partition, etc. But that may not be the facts because the merit of the case has not been gone into. This application was taken in priority, whether she has a competence to maintain a suit representing a person who is suffering from schizophrenia. That's the only case that was made out. But this application was opposed. We filed our objections contending that he is a person of normal state and he is not suffering from schizophrenia. The court allows the application, and on that application, I am now before this court. But the contention that is raised is under the Mental Health Act, there is a committee to be constituted. The court should have constituted a committee or referred the matter to a committee, that is a medical council constituted on the mental health, and then come to the conclusion, what is the percentage of the illness that he is
Para
suffering from.
21 is the answer, I think.
Para 21, of course, the learned judge gives the answer.
How it is, how that finding is not correct.
But the para 21, the learned judge does not send anybody to medical council.
So why it is not the court gives an answer?
But it does not give an answer.
Let's read it.
I'll just point out, I'll read it for my lords.
Yes.
As regards the applications of Mental Health Act 2017 is concerned, I am of the opinion that those provisions are applicable where a person is brought before the court with mental illness. This person is sought to be, this court does not test him also.
Yes.
And at that time, to provide him proper treatment, and also future course of the court has to send the concerned person before the medical board at the district hospital of the concerned district and secure report regarding the mental condition. And thereafter, the court has to form an opinion about mental health condition of that person, and then only the court will be able to deal with the matter. But in a civil litigation, the provisions of Mental Health Care Act 2017, more particularly in pursuance of several medical records, Exhibit P1 to P104, are, and also admitted fact, DW2 is an expert doctor, and if the first plaintiff is suffering from paranoid schizophrenia, I am of the opinion that this court need not secure the report from medical board by referring the first plaintiff for treatment, because DW2 being a psychiatrist has clearly admitted that till date, first plaintiff is under medication and he needs to take the following medicines. As regards the objections raised by the defendant 3 on IA5 and also in her oral evidence, after carefully going through her side of the evidence, I am of the opinion that mother of the first plaintiff has separated from family of the plaintiff, including PW1, as they are living separately from each other about 15 years ago. It's noteworthy to mention TW1 in her cross-examination has clearly admitted that 15 years She has not even seen nor talked to her son, first plaintiff, as she is residing in Koramangala, whereas the plaintiffs as well as PW1 are residing at HRBR layout, Kalyanagar, Bangalore. This shows DW1 has no personal knowledge of the mental condition of her son, first plaintiff, because she is not in touch with him. As such, she cannot argue on the mental condition of her son by ignoring the medical records at P1 to P104. The evidence of DW2, who is her own witness, it's relevant to note, DW1 in her cross-examination has admitted that her son is under medication in DW2 as well as Nimans, but she is not aware as to which type of disease first plaintiff is suffering from. Prima facie shows that
Why,
being.
according to you, he shouldn't be represented by the
Beg your pardon?
GPK? Wow. Why you are opposing the application? Where are your objections?
Blood, my objections, which I have filed it before the court. I have also filed an application. I have filed application and also made my statements. My application is at page 54, objections. 54, annexure D. All other respondents, suit is for partition. Properties were already partitioned. Documents also show that there was a partition. She wants the partition to be opened, etc. and all.
No, if the wife is representing the husband, what is the difficulty of the plaintiff?
No, blood. They have filed the application. They are not having any power of attorney or any such things.
No, like filed by the wife to represent the husband.
Wife represents the husband.
Husband saying that he is unwell.
Yes, he is mentally ill. That's her case. He himself can file the suit. When his mental status is perfect, they invited the application under 32 Rule 15. He himself could have filed the suit. And he could have filed the suit against his own brothers. His mental status is perfect. He had come before the court. The court had asked him certain questions before the learned counsel could come. He was able to answer.
The court observes that the doctor is examined. Doctor has presented to the court the medical record.
Doctor, at my instance, he was examined. I called him. He gave the statement that he is perfectly mentally all right. That's his evidence.
Where is that?
The evidence is on record. I think it is in Kannada. I may have to provide
What did he
translation.
say?
He says, Manoj, I had given him treatment and medications that are given to him, he is normal.
Last. Yes, with senior counsel.
Such an evidence is not there. 102 materials have been produced through the doctor during the course of an inquiry. All these material relating to prescription, medical report, doctor's opinion, everything. In every document it is said he is suffering from schizophrenia.
Do you deny that
Yes,
submission? made?
absolutely. It is not there. It is not there. It's a reference in the order. Doctor, what he said is also referred to by the trial court judge before in the impugned order itself. Yes, only contention put forth before the trial court is applicability of that law. The court below said that law may not be applicable at this stage. That was the opinion of the.
But the Supreme Court repeatedly, also all courts have said,
No.
even
As
in
far
an
as-
application.
As far as this submission with regard to what the doctor has said,
Yes,
you can point out, even if it is in Kannada, you can point out to him, he's saying it is.
right, it's in English, Manoj. My records have come, records are here.
Let's see, PW, who is examined at DW2.
He is examined as DW2. His examination in chief is recorded.
Can I read but not yes, deposed the examination thing? I am the consultant physician, psychiatric.
No, let him point out what is that, which paragraph of the.
That's right.
Huh?
Yes, Manoj, I'll point it out. There are certain portions which I could read.
Yes.
After going through the discharge summary at exhibit P12, I can say Narasimha Reddy had issues of anger, poor communication, reduced sleep, appetite. He was admitted to Spandana Health Care Hospital on 27/2/2012, 4/5/2012. On the date of discharge, mental status of Narasimha Reddy was normal with normal cognitive functions, adequate personal care and good initiative at work. Further, Mr. Narasimha Murthy had poor inclination to take medicines. As per Exhibit P12 in the year 2012, Narasimha Reddy was capable of discharging all normal functions as a normal human being. On 24/2/2018, Narasimha Reddy again brought to our Spandana Healthcare for outpatient care. As per P13, even on that date, based on the records, I can make out Narasimha Reddy was still on treatment for schizophrenia, no medications or addictions. In said document, I have also commented his poor motivation for socialization and work. Person with schizophrenia disease, proper medications is provided. He can do all work as a normal human being. As per available records, Narasimha Reddy in the year 2018 was a qualified person. He was able to interact with any person. P13, when I inquired Mr. Narasimha Reddy about medications, his response was positive. Additionally, for such patients, psychiatrists used to give injections, T-Tensil, 15 days on medications, medicines, and also person with such schizophrenia disease could be normal, healthy person, and he can lead a normal human life. That's his opinion.
Yes.
Your lordships may kindly see. Cross-examination. I know reading, writing Kannada as well as in English.
What he did is examination, Chief.
Yes.
It's a cross-examination.
Examination in chief, not by affidavit. My lord. He was examined at the instance of the court. It's a court witness. He was examined.
Yes. Yes, what did he say in the cross-examination?
My lord, the examination chief, this is he said. In the cross-examination, my lord, your lordships may kindly say he said, I know reading and writing in Kannada. I am working from 2005 on Spandana Healthcare, Nandini Layout, Aldo Spandana Nursing Home, Rajajinagar, Bengaluru. I do not know Rama Reddy, referendum number 1 of the suit. I have treated Mr. Narasimha Reddy from 2012 to 2018 as per the medical record available in the file. In our hospital, there is item of 5 psychiatric specialists, but I am only treated Mr. Narasimha Reddy. It is true to suggest that as per Exhibit Peter, Narasimha Reddy had lot anger issues. May kindly make me. Anger issues. I do not have medical records. Narasimha Reddy, as such, I cannot know how was medical condition. Said patient from 27/2/2012 to 4/5/2012. However, based on the discharge summary, I can say that mental condition of the patient was good when he was discharged from our hospital. As per Exhibit P13, Narasimha Reddy had poor motivation, socialization and work. As per Exhibit P20, as on 14/7/2014, there is a mention of need of an ambulance services because of patient on his own could not have come to hospital. That is why help from his family members was needed. It is true that paranoid schizophrenia is a treatable disease like hypertension and diabetes, but it cannot be completely cured. This is the cross-section. A medical prescription of 2725 was shown to the witness and asked about the following medicine. Question is, can you say for which disease above 3 medicines doctor will advise to any patient? As serial number 1, 2, 3 are the patient who is suffering from paranoid schizophrenia or psychosis. The medicine at serial number 2 is meant to the patient suffering from depression. The said medical prescription admitted by witness as such marked Exhibit 104. It is false to suggest that paranoid schizophrenia is equal to mental depressive disorder. It is true to suggest that generally such patient medically terminology, it is considered a disorder of thought process. This is his opinion. I do not know what is the present condition of Narasimha Reddy. According to me, in the year 2018, Narasimha Reddy was qualified person since he is not declared disqualified. I have not given or issued any document to suggest Narasimha Reddy in the year 2000 was qualified person. It is false to suggest that to help the dependent, I am saying that Narasimha Reddy was a qualified person when the suit was filed. In the year 2018, Narasimha Reddy was competent to file and prosecute civil litigation. He can enjoy all rights. I did not suggest refer to Narasimha Reddy to Nimans. This is the cross-examination. This is the evidence. Schizophrenia, my lord, even according to the medical jurisprudence, it is not a mental disorder like madness or otherwise. It is a kind of disease, my lord. If lordships want, I can take the features of these diseases from the medical jurisprudence by tomorrow itself. I can show what exactly the nature of.
That is not.
Admittedly, he is suffering from the schizophrenia, is not in dispute. And there are 102 materials are available on record to show he is suffering from the disease, incapable of understanding what would be the situation he is going to visit. All these materials have been examined by the trial court. Finding was recorded, holding that he is not capable of understanding the things. Therefore, wife was appointed as the guardian to the husband is concerned. It's a 227 petition, my lord. It is not 226 petition. The findings are recorded based on material. There would not be any perversity in the findings of the trial.
Some rulings which I point out, the Supreme Court also said medical board can give percentage of a schizophrenic disease. But even a military officer suffering from 15% is reappointed. The Supreme Court said 20% or 15%. Percentage of schizophrenia can only be assessed by a medical board by examining him. But the rulings which I point out, it's the first ruling, Your Honors could, my lords could kindly see. Of course, that's on the Hindu Marriage Act. The kindly turn to the first judgment is at page 1.
Para number.
Para. Lords may go to page 8, my lord. That was what was contentions that were raised. Then the considerations were given. This is a settled position. Turn to page 16.
I think your copy is here.
Page 16.
Your copy is here.
Sorry, I marked it.
No, if you, it's okay. If you want, you can take it and give the other
It's
copy.
here. I too have it. Sorry.
No, yes.
Page 12, para 27, page 16.
Yes.
But the court, however, undisputedly is empowered to satisfy itself as to whether a party before it suffers from mental illness or not, either for purposes of appointment of a guardian in terms of Order 32, Rule 15 of the Code of Civil Procedure or Section 41 of Indian Lunacy Act, as also for determination of his competence as a witness. 32 Rule 15 of the Code of Civil Procedure and Section 41 of the Indian Lunacy Act. That's what was referred to under the provisions. Kindly turn to para 29. But this was the first of the judgments where this Honorable Supreme Court settled in cases of such mental illness. Para 29. It will also be relevant to note that court has power to issue appropriate direction for protection of human rights of mentally ill persons and to see to it that persons suffering from mental illness get adequate protection of the terms of Mental Health Act. Then the Halsbury's laws were mentioned therein. His liberty was mentioned insofar as that is concerned. But this judgment would take recourse in so far as the procedure to be adopted. Para 50 minute, the final conclusions that have come to conclusions. We wish to point out question as to whether a person is mentally ill or not, although may be a subject of matter of a litigation. Court having regard to the provisions contained in 32 Rule 15 of the Code of Civil Procedure of the Indian Lunacy Act, as also the purpose of judging his competence to examine as a witness, may issue requisite directions. It is therefore not correct to contend that the aforementioned purpose, the court has no power at all. Prime concern of the court is to find out as to whether a person who is said to be mentally ill could defeat himself properly or not, defend himself properly or not. Determination of such an issue, although may have come relevance with the determination of the issue in the list, nonetheless, the court cannot be said to be wholly powerless in this behalf. However, it is one thing to say that a person would be subjected to a test which would invade his right of privacy and may in some case of battery.
You can refer to the paragraphs. I'll
Yes,
go to
ma'am.
that.
I only refer to the paragraphs
Yes.
which is spread. Now, this
Then
matter,
Next matter, CRP 110 of 2017, which para?
CRP 110, there also, the court, may I refer to the Kerala judgment, which there's at page 36,
Para number?
page 4, there is no para 5. Kasturi Bai's case, that is the previous judgment that was followed. But there, the Kerala High Court took consideration by Mental Health Care Act 2017 and 87 of the Mental Care Act, person suffering from mental retardation or mentally retarded person excluded from its operation under the definition mentally ill, mental illness, presumably that what is contemplated under the above said act, a judicial inquisition pertaining to the mental illness, lunacy, unsoundness, mind insanity, or mental retardation. Corollary is the first limb of Rule 15, which would come into operation only there is an adjudication under the inquisition proceedings, competent court authority adjudging a person of unsound mind before or during the pendency of the suit, court is bound to accept such adjudication under the first limb of so and so. Kasturi Bais was referred to, and then court in the last paragraph, my lord, my lords could see para 39 ink page. The procedure then available is to refer the parties to a medical board as to obtain a report regarding mental ailment, retardation, so and so, impairment of mental ability to take a rational decision pertaining to his affair or to protect his interest. The extensive jurisdiction vested with the court under 32 rule of CPC is elaborately considered, so and so, so and so. Now, therefore, that case also, medical board was, party was referred to medical board. But even here also, the evidence is not sufficient. Court could have sent him to a medical board for his.
Yes.
One judgment, where Kasturi's case, I'll skip that judgment. A military officer was under an appointment, his disability at page 79. That's a case of schizophrenia and disability. Page 79. That's a case where the Armed Forces Tribunal 79, it's reportable that
Yes.
schizophrenia, the third line, invading the medical board found appellant to be suffering from schizophrenia, which is disability, was assessed at 20% for a period of 5 years. Opinion of the board was that disability was neither attributable to nor aggravated by military service, and consequently, appellant was discharged from the army in so and so. But he was discharged. Thereafter, he was taken into service on the recommendation that his percentage was 15%, and he was still capable of working. Now, person having a disability of 10% or 12% or 15% can lead a normal life. And even if he is suffering from schizophrenia, he leads a normal life. And he can take care of himself. The litigation and the properties, his mother, his brothers, he can always fight his case for himself. Therefore, the order of the court is in isolation of a report of a medical board. He should have obtained a medical board's report. That was nothing, within a month or 10 days, they could have secured it. The board is a district board that could have secured it. But even this doctor, he examines it in 2012 or 13. And in 18, the patient was not available for him to be examined also. Therefore, my submission is, the order of the learned judge is contrary to the Mental Health Act. And the law laid down therein that the act applies. Whenever a person is called schizophrenia, you must get a report from the medical board.
Yes, third result.
That in all those matters where judgment is halted, I have come across, in all those matters, issue was the maintenance as awarded against the husband in a diverse matters. A husband came up with a defense in many of the matters of that nature, saying that I could not able to make the payment of maintenance because of the medical illness or mental schizophrenia like that. In those contexts, Supreme Court laid down the law, what has to be done. It is only an order 32 rule 15 application. And then 2012, a power of attorney was executed in his favor. It is their burden on their part to prove that power of attorney, even they can summon the witness at that point of time. It is only an order declining to discharge the guardian and allowing application appointing the wife as a guardian to the so and so husband. It's only there would not be no serious gravity in the matter, what my learned friend wanted to address.
They invited the problem. They
Correct.
should have said what could have been done by them. They filed the application. They insisted the application.
Next.
Cell number 4, T. Sheshgiri Rao for petitioner. Ashwin E. Raj for respondent.
In this matter, the question not which is arising is with respect to Order 22 Rule 10,
Order 22.
22 Rule 10. Now, my lords,
The application is allowed.
application vis-a-vis a list pendants purchaser, my lords, contravening an interim order of injunction where, my lords, a decree has been passed for the relief of partition. In a appeal, my lords, the appellant has filed, the court passes an order that none of the parties shall alienate the property. It is at this point of time, my lords, the alienation is effected.
What is the suit for?
It's a suit for partition. It is decreed. So the plaintiffs are in the current petition and we are the respondents in the regular appeal. While the pendency of the regular appeal, my lords, the court has made it clear, none of them shall alienate the properties, neither the appellants nor the respondents in the appeal. This being the situation, my lords, the plaintiff number 1, this is the ticklish situation, my lords, which I feel has arisen now. Plaintiff number 1 on one hand, defendant number 1 and defendant number 2, my lords. Collectively, my lords, they have executed one sale deed in favor of a subsequent purchaser, contravening the injunction, the order of injunction passed by the appellate. Now, my lords, undoubtedly, it is a list pendants transfer. I am not questioning, my lords, the right of a party, my lords, to come on record in whatsoever capacity, my lords, as a party to the list here. My lords, but what is sought, my lords, is a substitution. My lords, under 22 Rule 10,
Purchaser is going to be substituted as a.
appellate, number 1. My lords, he can always participate in the litigation. I have no issues. My lords, when we generally see, my lords, generally, substitution under Order 22 Rule 10. Lords, generally we see that the language used in the code is also to this effect, that in other cases of assignment, creation or devolution of any interest during the pendency of a suit, the suit may, by leave of the court, be continued by or against the person to or upon whom the interest has been devoured, by or against. Now, my lords, I am seeing a situation where, on one hand, my lords, the plaintiff join hands in the sale. Plaintiff, my lords, who has a decree for partition, who is pleading that it's a joint family property, my lords, he has joined hands in the sale, number 1. On the other hand, my lords, the defendants who have resisted the partition, who say it is not a joint family property, my lords, they have also joined this sale. The other plaintiffs, my lords, are now before the court saying that it is not an order of per se substitution which can be allowed. They can always be allowed to come on record. They are entitled to prosecute the appeal. They are entitled to prosecute the appeal. Not substitution, not has its own effect, because not unlike impediment. There's one more fact which I've just left out. Not all this happens when there is an impleading application which is filed before the court. That is yet to be decided during the pendency of the impleading application. It's pending consideration. And during the pendency of the impleading application, my lords, an application under Order 22 Rule 10 has been filed. My lords, asking that.
Let's see what is the reasoning given by the court.
Please. The order starts at 19.
We'll read from the reasoning part.
24, my lords, would it?
Yes.
Admittedly, the present appeal is filed by the appellant, defendant number 1, Krishnappa, against the respondents challenging the correctness and judgment of the decree in OS number 350 of 2008, dated 25/3/2007, passed by the civil judge and JMFC Ramnagara in decreeing the suit filed for partition and separate position, holding that the plaintiffs are entitled to 1/8 share each in suit schedule property bearing survey number 313 and 314
measuring 4 acre 20 guntas and 4 acre 2 guntas, including 4 guntas of Kharab land situated Hosur village, Birdi Hobli, Ramnagar Taluk. It is true that respondent number 1 to 7 have appeared before this court through their counsel, and it is also true that on 9/7/24, applicant herein had an application under order 1 rule 10(2). Respondent number 2 to 6 had filed objection to this application, but the appellant has not filed objection to this said application and also to the current application. The learned counsel for respondent number 2 to say could submit that applicant is not a necessary party in this appeal as she has purchased the suit property pending disposal of the appeal. In support of the said submission, reliance is placed on Basuraju Madhu so and so. In this decision at para 16, their lordships have held that the appellate court, considering the provisions of 1 rule 10(2) and section 52, held that any alienation made by the defendant during the pendency of the appeal will be hit by the doctrine of lis pendens, and therefore the proposed impleading applicant is not a necessary and a proper party in order to enable the appellate court to adjudicate all questions effectively. On the other hand, the learned counsel for the applicant relied upon Honorable Apex Court judgment in 2005-11 SEC, Amit Kumar Shah and another versus Farida Khatun. In this decision, the question arose for consideration to the Supreme Court was that can an application for substitution of a subsequent transfer be rejected and the subsequent purchaser be non-suited altogether. In this decision at para 10, it's been held as follows. The power of a court to add a party to a proceeding cannot depend solely on the question whether he has interest in the suit property. The question is whether the right of a person may be affected if he is not added as a party. Such right, however, will include necessarily an enforceable legal right. Under order 12.
I've seen. We'll ask him.
Please.
Yes, yes.
The only short point here is, Manoj, first fact is, Manoj, it is not in contravention of the interim order, Manoj. The interim order was dated.
No, whatever it is, you are a pendant-like purchaser.
Please, Manoj.
Why should you be substituted as an appellant?
Fellowship is covered by judgment saying that it can be come under order 22 rule 10 or order 1 rule 10, Manoj.
Take that.
2013-5 to other side.
Thompson Press?
Yes.
Is it Thompson Press? Nanak Builders Thompson Press? Yes. I
Para
have
53, Manoj.
I would rely on the same thing. That is the ticklish issue, not satisfied.
Paragraph number?
53, Manoj.
That's a suit for specific performance.
There is therefore little room for any doubt that the transfer of a suit pendent litter is not void ab initio and that the purchaser of any such property takes the bargain subject to the rights of the plaintiff in the pending suit. Although the above decision do not deal with the fact situation where the sale deed is executed in breach of an injunction issued by a competent court, we do not see any reason why the breach of such an injunction would render the transfer, whether by way of an absolute sale deed or otherwise ineffective. The party committing the breach may doubtless incur the liability to be punished for the breach committed by it, but the sale by itself may remain valid as between the parties to the transaction, subject to only the directions which the competent court may issue in the suit against the vendor. The third dimension which arises for consideration is the right of a transferee pendent elite seeks addition as a party defendant to the suit under Order 1 Rule 10. I have no hesitation in concurring with the view that no one other than the parties to the agreement to sell is a necessary and proper party to the suit. The decision of this court has elaborated aspects sufficiently, making any further realization unnecessary. The High Court has understood and applied the legal positions correctly while dismissing the application of the appellant under Order 1 Rule 10. What must also the same be addressed whether the prayer made by the appellant could be allowed under Order 22 Rule 10, which is as under. Then, Manoj, para 55 at the next page, Manoj. We are not on the virgin ground insofar as this question is concerned. Decision of this court have dealt similar questions and held that transferee pendant light can be added as a party to the suit lest transferee suffered a prejudice on account of the transfer losing or interest so and so, Manoj. Then, if I may request, Manoj, last is at 57.4. The appellant shall, as a result of this addition, raise and pursue all such defense as be available taken in the. So therefore, Manoj, the court has permitted to come under order.
I think we have to read further.
Please, Manoj.
A simple reading of the above provision.
No, that is, please, Manoj, a simple reading of the above provision would show that in cases of assignment, creation, or devolution of any interest during the pendency of a suit, the suit may, by leave of the court, be continued by or against the person to or upon whom such interest has come or devolved. What has troubled us is whether, independent of Order 1, Rule 10, the prayer of addition made by the appellant could be considered in the light of the above provisions, and if so, whether the appellant could be added as a party defendant in the suit. Our answer is in the affirmative. It is true that the appellant application with the appellant made only under Order 1, Rule 10, but the enabling provision of the Order Rule 22, Rule 10 CPC can always be invoked if the fact situation so demand. It was in any case not urged by the counsel for the respondents. The Order 22, Rule 10 could not be called in aid with a view to justifying the addition of the appellant as a party defendant. Such being the position, all that is required to be examined whether the transferee pendant letter could, in a suit of specific, be added as a party defendant, and if so, on what terms. We are not on a virgin ground insofar as the question is concerned. Decision of this court have dealt with similar situation and held that a transfer pendant can be added as a party to a suit, least the transferee suffered prejudice on account of the transferor losing interest in the litigation post-transfer. Then, Manoj, it refers to the judgment, any of the so and so. So therefore, Manoj, the ultimate conclusion.
What do you say? This is the only judgment you're.
This is a summons.
Yes. And that is the least of the problems, not the operation, because 22 Rule 10, a devolution of interest, either succession, legatee also can come under Order 22 Rule 10. That is not the problem. The problem is with respect to the nature of pleas, what is entitled to raise. That is why the Supreme Court in this matter, 57.4 for a moment. The Supreme Court said a purchaser of this sort is only entitled to such plea. He is bound by the pleas of both his vendors there. Kindly see 57.4. There are two decisions. It is supplemented by Chief Justice Thakur.
Just to intervene, the same condition has been put in this judgment also.
Just pause.
Therefore, 57.4 has been imposed.
Yeah, may I just point out? The appellant, as a result of his addition, raise and pursue only such defenses.
In this order also it is incorporated.
Which
In the present order also this is
may not be because
Para 14, page 32.
May I just clarify the factual thing. Then the same thing was because it is not just there are two opinions in this. Both are supplementing each other. So one was by Justice Iqbal and the other one was by His Lordship Justice Thakur. So both are on the same footing. There is no doubt with respect to the opinions which are concerned there. In fact, in the other one also, that is, if I'm not wrong, this was one of the leading laws which constricted the law of raising a defense or the law of pleadings with respect to such purchasers. And at 421, I'm sorry, at page para 45,
yes,
the defense or pleadings is available to all such defenses which are open, not to the vendor there. Does your lordships get it there?
45.
45 there.
Before parting with the.
Yes, yes. That is again supplemented again by the other opinion of His Lordship Justice Thakur at 57.4. This is the important law, where the pleading assume what sort of stances can be taken by a subsequent purchaser. Now, why I am pointing out an aberration would be caused under Order 22 Rule 10, because one cannot embrace the stance of a plaintiff as well as a defendant. Here, the sale undoubtedly has been effected by plaintiff number 1 on one hand, defendant number 1 and defendant number 2 on the other hand. We cannot have the stances of all these people admixed together in a communion in single person, which is the issue. This is why I pointed out this is the aberration which may be caused. But absolutely under Order 1 Rule 10, I don't think there can be any objection that a person coming before the court as a lispendence purchaser, bona fide, not bona fide, that may not be the question. He is entitled right to participate. This is the question which ought to have been considered. And that too, it's a suit for partition. It's a suit for partition. Every plaintiff can become a defendant and defendant can become a plaintiff here. Plaintiff has raised a separate plea. Now, if the court is saying that you constitute yourself as an appellant, what happens to the plea of the plaintiff? Can the court say,
The suit for partition is decreed.
The suit for partition is decreed. And this is,
Defendant is in appeal.
the defendant is in appeal. And one of both the defendants and one of the plaintiff may not conjointly sell this property. If it was purely a defendant in question, may not, absolutely this aberration would not have been the issue in controversy before this court. Either the plaintiffs on one hand, I would have said, okay, he will follow the stance of the plaintiff, nothing more, nothing less. If it's a defendant, it's the stance of the defendants. Here is a case, may not, where it's an admixture.
No, man, the question is already addressed, page 32, man. What is interest is taken care. Therefore, to come on conclusion, the applicant so-and-so is necessary party to the appeal to proceed with the appeal by raising the only defenses raised by the appellant, defendant number one before
What
the
about
trial court.
that is the defense. What about the stance of the plaintiff? This is where I said, my lords, the court is now telling.
Plaintiff is not there, my lord. We have come in as a defendant appellant who is before your lordship. That is the stand we are taking.
My lords, do they, then, my lords, the question is, don't they substitute the plaintiff also there? Plaintiff number one.
If you take plaintiff, we lose the property.
This is the place where I said, my lords, this is creating an aberration. Court cannot strike off the pleading of one single party vis-a-vis an assignee is concerned. This requires some sort of a consideration. The law with respect to a successor and his pleadings, my lords, is quite clear. Where, my lords, even a successor, my lords, for instance, a will. For instance, my lords, there might be a will sometime.
Yes.
There might be a sale, there might be something else. No, the court cannot say, you choose only the pleading.
I understood your submission.
This is the point. But I would say that 1 Rule 10 is applicable. He can always come. And your lordships can say this. If I'm not, all they want, says their interest is, they are intending to say that, what if you collegially withdraw the appeal? What should be my fate? This is his understanding. Your lordships may say that he may be permitted to transpose. But this is out of what I just pointed out. But substitution can create an aberration. Just imagine what could happen in the course of the final decree proceedings later on. The stances which are available, the equities then. This is why, at this stage, in a suit for partition, it could cause greater hardship. If the end can be achieved by various means, but I am pointing out this may not be not the substitution, because it would.
I understood your submission.
This is all I said. I think my lordships could put it as ease, my lords, by following the route where he can still be allowed to prosecute with that necessary orientation. I am grateful.
Pass over matters.
But should there be any supplemental judgments? I don't know. Should there be any supplemental judgments for this to explain how the stances are to be governed? Not yet. I'm grateful.
Yes.
Pass over matters. List number 1, serial number 4.
Lords,
Priya.
the respondents filed a suit in which I was not a party. And that suit ended in RSA number 477 of 2006. And my suit was dismissed, the suit of the respondent was dismissed. I was not a party to this proceedings. And the RSA, the judgment in RSA has attained finality, and it was decided in the year 2019. Before that RSA was decided, they filed suit against me for eviction law. When the matter was pending, when the title was not yet declared, they filed a suit against me, and I had no information, no knowledge of the earlier proceedings below. And that suit filed against me came to be decreed, and it was confirmed by this court. And later, subsequently, I came to know that this judgment in RSA number 477 of 2006, I came to know of this, and I filed SLP Milord. And the Apex Court granted me liberty to.
Why now it is, so you are on the maintainability of the writ petition.
Yes, Milord. That's why I'm coming there.
And order 21 rule 105.
101, Milord.
101, an order is passed.
Yes, Milord.
Whatever is the order, what is the remedy?
Milord, my specific case is that the decree upon which they are relying, they are not, the suit I have filed subsequent to the subsequent order of Apex Court.
If an order
Yes,
after the court is
yes,
passed,
Milord. Yes.
that would be
They are not the
decided by-
title holders, Milord. My case is they are not the title holders.
That would be decided by the court, from which the order can be appealed, there can be a revision, there can be a, so.
No, Milord, my
basic-
application is not at all considered. It is not upon it is not adjudicated.
If it is not properly adjudicated, the appellate court where you have a right of appeal will take care. Why do you want to come to
My
this
lord,
court
I
now?
filed I'm filing with authority, my lord.
Take that.
The second judgment, my lord. The second judgment,
Yes, page number.
para number 21, my lord.
Page number.
Page number 29, para number 21. Para number 21,
Yes.
the running page, my lord. The fifth line, Order 21, Rule 101 provides for the determination of necessary issues. 103 clearly stipulates that when an application is adjudicated upon under Rule 98 or Rule 100 of the said order, shall have the same effect as if it were a decree. Thus, it is deemed a decree. If a court declines to adjudicate on the ground that it does not have jurisdiction, the said order cannot earn the status of a decree. If an executing court only expresses its inability to adjudicate by stating that it lacks jurisdiction, then the status of the order has to be different. In the instant case, the executing court has expressed an opinion that it has become in functus officio and hence it cannot initiate the launch or inquiry. The appellant has invoked the jurisdiction of the High Court under Article 227 of the Constitution.
The court do.
Pardon me,
The
Lord?
court has never said that it is not, it is functus officio or it has no jurisdiction. That is not the court said.
Court has said, I'll read out the relevant portion of the impugned order, my lord. My suit, subsequently I have filed suit for declaration that the judgment.
Rejected on the merits of it.
Yes.
At page number 127.
Yes, ma'am. Lord, reading the above makes it crystal clear that the objector cannot avail both the remedies. This is the reason. Both the remedies, just remedies of suit as well as application under Order 99, 100, 101 of CPC, as to do would be in the vulnerable words of the Honorable Full Bench, be in the depth of Rule 101 Order 21 CPC, which has been enunciated by the Honorable Supreme Court in the case of Nuruddin versus KL Anand. Thus, the simultaneous proceedings undertaken by the JDR as an objector by way of the suit, as well as resistance application may result in the conflicting decrees. So this is the reason, since the court has come to the conclusion that I have also filed a suit, therefore this application is not maintainable.
That is a finding that you cannot maintain your objector application is rejected.
When there is no inquiry, my lord, when there is no inquiry upon my application, there cannot be a decree.
Yes, that is a lapsus on the part of the court which you would assail before the court which is having jurisdiction to do it, not before this court. The office objection with regard to the maintainability of the appeal is upheld and the petitioner, the petition is dismissed dismissed with the liberty to avail the appropriate remedy within a period of 15 days from the date of receipt of the copy of the order. The registry should return all the documents. Yes.
Case number
Yes.
17, Srinivasa GA. Case number 17, pass over. Srinivasa GA.
Yes, next, call the next matter. This matter after 2 weeks.
17. This is a suit of 89, Lord. FDP of the year 2016. The final decree proceedings are pending from 2016 till date. And there is no hope of completion because it is going on getting adjourned. Just request early hearing a decision before at least within 6 months. If
Why
it
it
is,
is pending from 2016? Where is the order sheet?
order sheet is there, Lord. Page 26 is the order sheet from 2017. For one reason or other, it just it's getting one of the brother who is in control of the property.
From petitioner. You are the?
I'm one of the respondents. I'm willing, but I'm totally cooperating because
Respondent number 2 you appear?
yes.
Great time on the ground of settlement.
I'll just, I am respondent number. Just point. In the decree, FDP.
Respondent number 4.
4, I'm 4. Madhu.
Learned Counsel, respondent number 4 is present. No
Yes.
representation from petitioner.
But one of the brothers.
IA numbers 5 to 7?
IA numbers 5 to 7. Brother is. No, what is IA 5 to 7?
Right from 2023, these are pending. IA number
Yes,
4 to 7.
yes. But the court could dispose of the IAs and then take up the matter on the
Please
main.
come, the present petition is filed. Seeing the following prayer. Then senior counsel according to the petitioner submits that the FDP proceedings of the year 2016 and the same are on one reason or the other is being adjourned and pending on file of the so-and-so. Considering the submission of the senior counsel, considering the fact that the FDP is pending from 2016, this court deems it appropriate to pass the following order. The petition is disposed of directing, so they are requesting so-and-so to dispose of the FDP number 170 of 2016 as expeditiously as possible, but not later than 6 months.
Please.
Cell number 19.
Please, Lord.
This court is not issuing notice to the respondent as no adverse orders are passed.
Please.
And disposal of the case is in the interest of all the parties.
Please.
Yes.
19. Halli Shantappa.
Please, Mother, I am appearing for the petitioner, Mother. Petitioner is a plaintiff, Mother. He filed for suit for declaration and injunction, Mother. Your Lordship may kindly come to page 83, Mother. He filed an application for order 13 and 1 and 2, Mother. The trial court has not granted ex parte ad interim temporary injunction, Mother. They issued that emergent notice to the defendant, Mother. Yesterday, similar petition has been disposed of, Mother. That writ petition number 16669 of 26, Mother.
The present petition is filed.
Same that petition has been disposed of, Mother, yesterday.
What is the number?
That writ petition number 16669 of 9, Mother.
666 of
166 of 9 of 2026,
to
Mother.
change. 16669 26. Yesterday it is disposed. Yes, next.
Cell number 24. Cell number 24. History.
Yes.
My lords, challenge is on the execution petition. Execution, my lord. Petitioner is a judgment at all. My lord, a suit was filed by the respondent in OS number 47 of 23, my lord. And for a specific performance of contract in respect of 4 acres, 34 guntas.
What is
of
the
land.
IA that is filed?
My lord, IA was first, IA number 2 was filed for,
Say the execution of the case.
that is for IA number 3. Yes. My lord,
Bangalore
before
decides
that,
RFA number.
my lord, RFA number 2353 of 23. In respect of RFA number, my lord, your lordship,
If you stayed, if you want stay, you should seek it in the RFA. Why should
in
you
the
seek it
RFA, my lord, there is an interim order, which is at page 55, my lord, annexure J. Kindly see the page.
50?
Page 55. My lord, may I read, my lord?
Yes.
Heard the learned counsel for the appellant in IA numbers 120 of 26 and 2 for 26. In view of the reasons stated in the affidavit filed, in respect of the applications, the delay of 84 days in filing, the recalling application is condoned. The order dated so and so is recalled. Accordingly, IA numbers 1 and 2 are allowed. The appeal is restored to its original file. Learned counsel for the appellant submits that the respondent plaintiff has filed an execution petition and the said court has directed to submit the draft deed and seeks to stay the proceedings.
Yes.
We have,
It is subject to outcome of the appeal. It has not stayed the proceedings.
it has
What
not,
if have not got in a regular appeal? Why should the executing court do it?
my lord, in this case, my lord, the court also observed, this court also observed that the matter requires consideration. My lord,
If this court
and also
observes
called
that
for the records.
If this court observes that it requires consideration, orders also have to be passed by this court. Executing
Please.
court will not do it.
But regarding the execution, there is an order, my lord.
It says everything can go on, it is subject to the result. So nothing has been stayed.
The original OS is not stayed. decree,
Execution is not stayed.
decree is not stayed.
Execution is also not
Execution
stayed.
is not stayed, but it has become subject to the outcome of the
So it will go
RFA.
on, it will go on. So that is
It will
whatever
go on, my
goes
lord,
on,
but if my submission is
that
that,
has to be stayed by the High Court in the regular appeal, not the executing court. What you can't get before the court, you can't ask the trial court. Please come.
my lord, only thing is that if this, the execution proceedings are not stayed till the RFA, my lord, is.
That you can ask the RFA court. The petition is before this court. Agreed with orders passed.
My lord, may I make one more submission? Execution was filed later, my lord. RFA was filed earlier.
Your
But
RFA filed earlier was dismissed for default, then restored.
Then it was recalled.
Then it was restored.
Restored.
And while at the time of restoration, all this order is passed. Court has taken note of the fact that execution proceedings are going on.
Please.
Still, the court has not stated.
But even the records were called, trial court
Get it,
records were
please.
called. My lord, my RFA will become infructuous if
If RFA
they
becomes
are.
infructuous, you should ask the court, RFA court, isn't it? How can you go to the executing court and say, you please stall these proceedings till RFA is decided? Why should it do? Then there is no stay required in any of the cases. Like this, you should file an application and the court should consider it.
This will lead to multiplication of proceedings,
You
my
should
lord.
have, that will remove the RFA, not.
But
not
the matter is posted for tomorrow, my lord. If the execution court completes, till then, my lord, at least interim order may be.
They're not entitled. Come, agreed with the orders passed. In I number 3, in OS, in execution number 20 of 2025, dated, what is the order date?
20,
29/4.
29/4, my lord.
29?
29/4/26.
29/4.
It's a common order. In
2026.
both the cases, common order was passed.
The
In
JDR
fact,
is-
my application, IA was not recalled. The
JDR is before this.
ex parte order was not recalled.
The JDR is before this court. Or by order impugned, the court had refused to stay the execution proceedings till the RFA number 2353 of 2023, filed with a judgment debtor before the High Court, is decided. When counsel for the petitioner submits that the petitioner has filed RFA in that the court had observed that the appeal requires consideration. And the court also observed that the execution of the sale deed either by the appellant or by the process of the court in favor of the respondent plaintiff would be subject to the outcome of the appeal. It is submitted that if the document, the sale deed is executed, it would cause a lot of hardship to the petitioner, and virtually the RFA that is filed will become infructuous. It is submitted that till the RFA proceedings are concluded, there may be a direction to the executing court not to proceed further. Next part, this court having heard the counsel for the petitioner, there is a material on record. When a judgment and decree is passed, the petitioner has preferred an RFA before this court. In the said RFA, there is no stay of execution, and except observing that any of the proceedings that take place, they are subject to the result of the appeal. No other order is granted. And then the petitioner has approached the trial court by filing the instant application. That came to be decreed, that came to be dismissed by the court, observing that the no stay is granted by the High Court. Hence, the court do not find any reasons to stay the execution proceedings. In the considered opinion of this court, the court had rightly considered the fact that there are no orders, the stay orders are not granted in RFA number 2353 of 2023 by the High Court, and as such rightly dismissed IA number 3 filed by the petitioner. is fine, hence this court finds no reasons to interfere.
List number 2, serial number 70. Prashant. List number 2, serial number 70.
Serial number?
70, that was passed over.
Pass over serial.
My instructions not. Within 3 months, not he was dispossessed by the original landlord. That is why no amount is liable to be paid. They are not in a position to make any deposit. 15 days time, Lord, by holding the auction and keeping not the attachment order as it is. Within such time, we will go to the commercial court and.
Can't grant such a relief, particularly looking at the conduct of the party, who has been litigating, who is aware of the appointment of an arbitrator and come to the court now after, when was the arbitrator appointed? 2019.
22.
22, after
22.
4 years.
But he
you
was.
come to the court saying that only after this, and it is, you are having a, not one, there are so many litigations pending between the parties.
Please, but this was.
It is hard to believe that your party is not aware of this. And that, and whatever it is a decree where an award, where certain amounts were directed.
Even in the order appointing the arbitrator, there is a specific observation that the question of limitation is kept open. But the arbitrator, does not consider the question of limitation.
Go there. You didn't appear before the arbitrator.
But I was not,
So you
I
can't
was
agitate
evicted,
it.
from that property by way of a court order. That also, is a part of, the records before the trial court.
Will not it? Yes. Page, which item? Serial number? 70. Dismissed.
Please, correct.
So list continued. List number 2, serial number 5. Serial number 5, Sharman IS for petitioner. Kevin Narasimhan.
Let's see, senior is in quotal number 1, my lord.
An order in FDP, my lord, an order of appointment of a commissioner to partition the immobile properties has been called in question. In the RFA, my lord, the division bench of this court there are several RFAs filed by several parties. In all the RFAs, this court has said that drawing up a final decree proceedings has been stayed. Now, a commissioner has been appointed by the impugned order.
When is the interim order granted?
But interim order was granted on 5/2/2026, my lord. 5/2/26, my lord.
5/2/26.
My lord, Ravi Shankar sir is engaged in this matter, my lord. He is in portal 1, my lord.
Stay of interim stay.
The appellate court is seized of the matter. An interim order has been passed.
Where is the impugned order?
Impugned order, my lord, page number 70, ink page number 70, annexure E. Relevant portion, my lord, is on page 70, 72 and 73. 73, my lord's missing.
R14 unclaimed. Mega. Notice to R14 returned as unclaimed. Amounts to deemed service of notice. What is this 15? Who is R15?
Defendant number 10C.
One of the sharers, my lord. She has not objected to this order. She has not questioned.
Notices or not, sir? Notices or not, sir?
Publishing of process.
Is he sailing with you?
No, Lord.
They're not sailing with you. The notice to him is necessary to dispose of this.
But they have not contested if they were
No.
aggrieved by the.
Notice is not sent to them because process is
But
to be paid.
there is a stay of further proceeding. All parties are.
What is that order?
That order, my lord, is appointment of a commissioner to partition the properties.
What is wrong in that?
My lord, because the first heirs of the KB Gursiddappa.
Where is the order you said? Let's see.
Page 70, my lord, 70.
My lord, first heirs of the KB Gursiddappa shares are not divided, my lord. The plaintiffs and defendants in this
To
suit are,
appoint court commissioner to demarcate 1/12 share of each petitioner in the properties and to submit a report.
yes, my lord.
Oh.
Because my lord,
Why should it be stayed?
because my lord, the KB Rudrappa's heirs are before this court were the plaintiffs and defendants. Their grandfather KB Gursiddappa and his sons are not divided, and their share was not at all decided, my lord. As per OS 149 but 2014 suit is pending, my lord. Suit RSS pending, my lord.
Where are your objections to this IA?
My lord, objections was prepared, my lord. It was-
Where are your objections to this IA before the executing court?
To the?
For the executing court, have you filed
Yes,
your
ma'am.
objections to IA number 4?
Yes, my lord, it was at page number
Oh,
58, my lord.
58.
Lord, their case is, Lord, that
So let's see, what is that?
Because kindly come to page 68, my lord. Kindly come to page 68, my lord.
paragraph 20, page 62 is the objection.
Lord, may be permitted to read, my lord. Kindly at page number.
That is also the
67.
ground before this court.
No, the court is proceeding as per the preliminary decree. You cannot have any objection as far as
My
that is
lord,
concerned. That is part of the, that
My
is.
lord, my lord, kindly see, kindly come to the page number 67 of my arguments, my lord, to the IEA, wherein the item number 20 is the subject matter of the RSA, and item number 23
Let
is.
it be, because in RSC you don't have
Yes,
an
yes.
interim order.
Yes, my lord, I will demonstrate, my lord. I am submitting the documents to demonstrate how the properties involved in this suit are involved in the earlier suit, my lord. Because the earlier suit, the properties are not at all been divided in between the four fathers, my lord.
Pursuant to the preliminary decree, no the,
My lord,
no the court is
five-
proceeding.
out
Not-
of, my lord,
Ultimately,
My lord,
whatever your grounds are, now you can raise it before
my lord,
the.
kindly see, my lord, kindly take this memo of documents, my lord, to show the shares are not at all been decided in between the four fathers. Sir.
What did the court do in this?
My lord,
Respecting your right.
my lord, because the 7 properties out of 27 properties, 7 properties are not at all been decided in between the first year of the KB Gursiddappa, my lord. Without the adjudication of the first division of the properties in between the first years of the KB Gursiddappa, the second division of the properties cannot be done, my lord.
What is that is submitting? I'm not.
My lord,
Sir, my lord, I will.
all that is pending before the
That is what-
appellate.
No, my lord, no, my lord.
Something which is not part of the appeal.
Everything is a part of
My
the.
lord, kindly permit.
In
me to
fact,
see-
they have stated
Kindly
that
permit me to produce the documents, my lord.
So are you?
It's a
going to
harmless
agitate-
order.
No, are you going to agitate your rights independently before the executing court?
My lord, I am, there are 27 properties. Out of 27 properties, 8 properties are not at all decided between the. My lord, senior counsel is election for total for, my lord, kindly have it in tomorrow, my lord.
This has come up earlier also.
Come on.
When it has come up?
No, my lord.
Once, my lord,
On Wednesday, my
Even-
lord.
And
even during,
Friday.
No, it reached.
it has not.
earlier it is reached. and
Once
passed
it has
over.
reached and got passed over because senior counsel was.
Kindly have it.
I'm making it very clear to the advocates on the ground of senior counsel. I'm not going
My
to
lord, kindly
adjourn
permit me to produce.
any of the matters. If senior counsel is here, he will argue, or the advocate on record shall argue. I will not pass out any matter from tomorrow. Because everybody, wherever there is a stay, then that will never be vacated. Every matter there is a stay.
My lord, I am producing the documents.
Why did you produce it today? Why have you not filed it much before? When the matter is in the list and coming up from the last 3 occasions. The documents, are you not supposed to serve on the other side?
My lord, they are well aware of these documents, my lord, because they are also.
File the documents. Have you served a copy on them?
My lord, I am producing only the genealogical tree and the.
And they doesn't require to look at the documents.
My lord, the genealogical tree for the.
Please understand, that's
Yes,
not
my
the
lord.
submission.
Yes, my lord.
Even they may be having. When you're referring, they should have the advantage of looking at it. This can't go on every day. List this matter on the top of the list tomorrow.
Grateful, ma'am.
Grateful.
Well, intimate.
And if any, even a request for passover will not be considered, on that ground, the writ petition will be dismissed. Intermod earlier granted is extended.
Right.
It's next.
Number 6. Number 6. P. Sheshgiri Rao.
The respond number.
Fine. Yes.
It's a defendant's writ petition emanating out of the suit for partition. The applications under consideration were 3 amendment applications, not 1 minute, 3 amendment applications filed by the original plaintiff. Because all 3 minutes were to include certain properties. Again, now minutes, the applications minutes which are under consideration minutes are IA number 9, IA number 11, IA number 13 minutes, which are the applications minutes, the amendment applications.
No, against all the 3 applications, you have filed only 1 writ petition.
Yes, but it's a common order, so there's a common writ petition which is being preferred. Which one?
Why you have filed 3 IAs for amendment?
Not me, not the I am the defendant.
You are the defendant.
I'm
Why 3 IAs are filed seeking amendment?
Yes, but now IA number 9 was filed stating not that subsequent.
Suit is what? Suit is for?
Suit is for the relief of partition. It has been filed in the year 2017. And if my lordship would see the original plaint, my lords.
IAs are filed in which year?
I beg my lordship's pardon.
IAs are filed in which year?
IAs have been filed, for one moment. IA number 9, my lords, has been filed, which your lordship will see.
On 16/1/2023.
6 years subsequent to the suit.
10?
10, my lords, is.
No, IA number 11.
Yes, please. IA number 11, my lords, 16/1/24. And then IA number 12, my lords.
13.
I'm sorry. IA number 38/2024, my lords, is IA number 30. So serial item, my lords, is there are 3 IAs which have been filed. Now, my lords, insofar as the plea of the plaintiff, my lords, was to the effect that these were all, my lords, the co-parcenary estates. And my lords, there was a partition which was effected, registered. My lordship will find the pleading at para 5 of the plaint. This is the original plaint, my lords, at 29. Does my lordships get the 5th line from the top, my lords, which indicates a registered partition, which is dated 4/11/1998. Now, my lords, this is a partition of the year 1998. The plaintiff is in her full knowledge and senses about this when the suit has been filed. The first IA, my lords,
So as far as IA number 9 is concerned,
yes,
they have no objection.
No, sir. Only vis-a-vis the prayer is concerned if my lordship.
You have no objection. IA number 9.
Please,
With regard to the correction
IA
of
number
the name.
9 minutes, what they have sought is annul the partition registered in the year 2000. This is what they say, minutes after 6 years after entry into the suit. Your lordship may kindly see 68, the proposed amendment. This is the nature of amendments minutes which have been sought here. And then minutes, kindly see. Minutes, These properties, my lords, which are standing in the name of the brother, my lords, ideally, I would have said, let a trial go
Why
on.
you're the family member or a purchaser?
Because I am the family member, brother. Then, my lords, kindly see, the heights of which, my lords, it goes on, after that is, my lords, if your lordships could,
There is a finding with regard to why these applications are allowed.
please, my lords, I'll just take my lords. My lords, can I just complete two other heights, my lords? IA number 11, my lords. This
No,
gentleman,
that we will go later. Please.
a
come
government
from the-
quarry is sought to be,
Huh?
a government quarry is sought to be, my lords, sir.
No, no.
Yes, please.
Even if you look at the order,
Yes,
where is the reasoning?
Please, I'll take my lordship. Annex A for a moment, it's page 19 it starts and,
No, the suit is of the year 2017.
yes, my lords.
After the dependent's evidence started, they have filed this IA.
At the time, my lords, yes, and my lordship would see the findings starts at 24, my lords.
I've seen that, I've read that.
Yes, please. And, my lords, I would just point out that,
No, just what, if you see,
yes, my lords.
12, 13 is also part of it is discussion.
Yes,
14, the defendant number 3 has contended that the applications are filed
Yes,
once the issues have been framed.
Yes, ma'am.
Admittedly, none of the parties have led their side of evidence, and it's just unnecessary to allow the application filed by the plaintiff. Proposed amendments are necessary to decide the real question in controversy.
This is the order. This is all the order.
Yes.
My lord,
There is a reasoning in the order. And what were you doing from 2017?
My lord,
Why did you come up with in 2023? And where is the reasons recorded? by
point
the
is,
court?
my lord, in 2017, it is no doubt I had filed the suit in 2017. Subsequently, the matter was delayed in the trial court and the issues were framed. At the stage of submission of our evidence, we have noticed that there were certain defects in the discrepancies so far as the names are concerned.
That is.
And then
They
so
have
far
also
as
no
the said,
objection.
my lord, your lordship may kindly appreciate, this is a suit for partition. She is the married daughter of her parents. Parents died. A partition had taken place way back in 1998. Certain share has been retained by the parents. Now we are concerned only about the shares of the parents only. We are not saying anything about the shares given to the brothers. Certain portions are given to the brothers. They have been enjoying. We have nothing to say. Now, certain portion had been retained in the name of the parents, and pursuant to the death of the parents, we have filed the suit, my lord. Father died on 19/5/2017. It is only at the later stage, my lord, these.
How come that fact was in your knowledge in 2017?
My lord, 2017, after the death of the father, my lord, we have verified, we have tried our level best to ascertain the facts. Then this brother was not cooperating. Now, brother.
It took 8 years.
My lord, in 23, we had filed an application for.
That is in respect of one. 24,
one item.
another one.
Then, in so far as IA number 11 is concerned, it is pertaining to the leasehold right of the property. When the father was there, he had taken the property on quarry license.
Issues were framed.
Issues have been framed, my lord. The suit is in the stage of evidence.
So,
Evidence is not commenced, my lord. Evidence is yet to be commenced.
the moment the issues are framed, that is commencement of the trial. So after commencement.
My
of
lord,
the trial,
she had no knowledge about these things, my lord.
where did you say, where has a court recorded? That is what I'm asking.
My lord,
I'm only on that point. Where is
my lord, the court has considered it and then passed this.
no consideration, all your contentions. At the end, it is just unnecessary. How it is just unnecessary? Court, it doesn't even say.
Because it is still in the primitive stage, my lord, because now if this amendment is allowed, my lord, they will be having an option.
No, after comment, that let the.
My lord,
court
they will
say.
be having an opportunity to file their objection. Then no prejudice will be caused to them.
Order said so. Court can only understand from the order, not from your arguments. What did the court
No,
say?
that is true, my lord.
Court doesn't say anything.
I cannot improve the court order by my arguments, my lord. That is true. But the point, my lord, we have included the properties which were found in the registered partition.
Come to your
But
affidavit.
subsequently,
Come to the affidavit that you have filed in support of these IAs. Leave that IA which is filed for correction, remaining IA.
page 63, my lord.
Page?
Page 65. Annexure E, that is IA number 9.
71, my lordship will get the reasons.
To add the name of the mother. This is.
Name of the mother, then name of the property.
Which
so
they
far as
have no
those
objection,
concerned,
as far
they
as
won't be
that is
having
concerned.
any objection. Then, my lord, in the plaint, my lord, we had sought for deletion of para 5 and inclusion of para 5A, B and C.
Where is that discussion in the order? Why you wanted to delete 5?
My lord,
Add something, and what
it is
the impact?
only to avoid the overlapping of pleadings we had sought for deletion. It is not that we are going to withdraw any admissions made in the plaint. We stand by it. Whatever is pleaded in para 5 has been reproduced in para 5B.
So we have to gather so many things from so many places to understand this order.
Lord, therefore, my lord, we had,
Hmm?
so now their, I think their main objection is that we had sought for a deletion and it cannot be deleted. That is their objection, it seems. That's what the other side had argued on the last date. It is not so. And even if that is retained, we will not be having any objections. Even if for retention of this,
Let it be retained.
please, my lord, we have no objections. Nothing will happen if that is retained.
Let the court pass an order. Why it is allowing it? I can't understand from your submissions, what is it? What is the, why the court has allowed this application? And what is the effect of it? Now, for that, we have to read all the, the plain, traditional, plain written statement and everything. We have to read and understand.
Lord, the 227, my lord, the scope is,
No, 227 court has to read everything.
no, it is limited, my lord. The court has exercised the discretionary power. The court found that since it is in the primitive stage,
Should be, no,
your lordship may kindly consider, there are two aspects.
judicial reasoning.
Your lordship may kindly appreciate.
With the some judicial reasoning, where is the reasoning?
What is required, what is necessary for,
Nothing was discussed. Nothing was discussed. Where is the deletion discussed by the court? Please come to the order copy and show me. You have wanted to delete one paragraph. Where is the discussion? It can't, the court cannot do in such a mechanical manner.
the court found that since it is in the primitive stage, my lord, evidence has not been recorded. So, no prejudice would be caused to the other side. That is the reason why the trial court had exercised the discretion.
Set aside this order. Let the court pass and consider the objection. Yes, the petition is, the order is, I'll dictate the order later. The writ petition is allowed, the order dated so and so is set aside and the matter is remanded back to the court. So fresh consideration. The court has failed to give any reasons. Court considering the objections of the respondent shall pass a recent order. All other matters will come tomorrow. It won't reach because everybody want the matters to be heard and the court cannot hear it. So it won't reach.
My lord, serial number
If there is
78,
any
list number 3.
urgency, if there is an urgency like the matter is coming tomorrow, then you please make a mention tomorrow in the morning, not now.
Lord, serial number 65 in the list 2, my lord. All the objections are clear, my lord. The matter may be come from the preliminary hearing, my lord.
Thirdly,
No, no, there's, one submission.
thirdly-
In the serial number 75, we have filed IA for paper publication as per the earlier direction. That IA may be allowed so that we can proceed for the paper publication, my lord.
Allowed when the matter is
list,
called.
list number 3, intermediate kind may best.
In all the please listen to the court. In all the matters, interim orders will be extended and the matters will be in the list. And whenever in the morning, only on the ground that the next day, if the matter is listed before the court, if any mentions are made, I will take up at 2:30. Other than that, I will not be expediting any of the matters to list one.
My lord, serial number 78, list 3. There are subvention batch scheme EMI matters, my lord. There are overall 43 matters, only 31 are listed today. Kindly the other 9 leftover connected matters may be listed, my lord. I made a list regarding that.
Part-heard matters. Whatever are the part-heard matters that time, that will be listed before me. The other matters will go before the court having roster. You make a mention there saying that the matters are there. If any orders are passed, then I'll be taking up along with that.
My lord, may I make a submission, my lord? List number 3, serial number 50, my lord.
I moved it yesterday. It was listed today for in the serial number 27, serial list number 3. It is not reached. May kindly have it tomorrow.
Urgency for that.
No, my lord, they already decree is passed. It is a writ petition is filed.
See, if all writ petitions are of same nature.
My lord, they are executing the decree.
Anything, that is when is it, when they are executing?
My lord,
There should be a date for that. If you mention a date, if it is coming tomorrow, it is urgent, then you mention, I will take it up in the at 2:30. Not all the matters. Everybody wants the matters to be listed. That's why I'm listing all the matters. Wherever urgent, I will take it up, mention in the morning. And not like that because you have filed the matter, I should take up. You make out a urgency, then I'll take them.
My humble submission, my lord. Serial, list number 3, serial number 51, kindly it may be called on Monday, my lord. They may not be in a position to appear.
ಏನ್ ಮಾಡ್ಬೇಕಂತ ತಿರ್ಗಾ ಬೆಳಿಗ್ಗೆ ಮೂವ್ ಮಾಡ್ಬೇಕಾ? ಬೆಳಿಗ್ಗೆ ಮೂವ್ ಮಾಡಿ
2:30 ಅಂತ ತಗೋಬೇಕು.
2:30 ಅಂತ ತಗೋಬೇಕು.
ನಾವು 2:30 ಕರೀತೇವೆ. ಮೇಡಮ್
ಲಿಸ್ಟ್ ರಿಪೀಟ್ ಆಗುತ್ತೆ.
ಏನಾಗುತ್ತೆ? ಲಿಸ್ಟ್ ನಂಬರ್ 3 ನಾಳೆ ಬರುತ್ತಾ?
ಮೇಡಮ್ ಲಿಸ್ಟ್ ನಂಬರ್ 3 ರಿಪೀಟ್ ಆಗುತ್ತಾ?
ಹೌದು ಸರ್, ಅದು 2 ಬರುತ್ತೆ, 1 ಅಲ್ಲಿ 2 ಅಲ್ಲಿ ಇರೋದು 1 ಬರುತ್ತೆ.
ಇತ್ತ ಮುಗಿಯೊಂದುಂಡು ಬಲೆ ಇನ್ನ ಆಯನ ಜೂನಿಯರ್ ಬತ್ತೇರು ನಾಡುದು ಕೊರಿಯೇ ಫೋನ್ ಮಾಡ್ತೆ ಬೇಗ ಮಸ್ತ್ ಸರ್ತಿ ಫೋನ್ ಮಾಡ್ತೆ ಮೂರಾಯ್ತು ತೂಲೆ ಎನ್ನ ಜೂನಿಯರ್